for leave for drawing up an order out of time.
Got it. My lord, I'm praying for the same or leave, my lord, for a different. পাঁচ করা আছে ঠিক আছে Item number 1 to be mentioned, Usha Martin Limited versus Al Sifa Minerals Private Limited. Oh, আচ্ছা আচ্ছা
Lordship, item number 1, I am for the petitioner. This matter has come up for substitution of the arbitrator.
Have you served notice on this?
Yes, Lordship.
Good service.
Lordship, it's by way of email. The party is based in Jharkhand, Lordship.
Oh. Despite service by email, comma, a printout of which is filed in court today by learned counsel for the petitioner, comma, the respondent is not represented in court when the matter is called on for hearing. Full stop. Such printout be kept on record. The matter was previously referred to arbitration. Full stop. However, comma, the arbitrator appointed previously has communicated to say that he has certain personal difficulties in taking up.
Lordship, if I may, we are unable to contact the arbitrator. A query was filed with the learned registrar, Lordship.
Previously could not be contacted as per submission of learned counsel for the petitioner, comma, in any manner whatsoever. Full stop. As such, comma, the arbitration proceeding could not commence till date. Full stop. In such scenario, comma, the arbitrator is required to be changed. Full stop. Hence, the AP number 45 of 2023. What is the valuation?
Lordship, roughly 1.2 crores, Lordship.
Hence, AP such and such 45 of 2023 is allowed, comma, thereby appointing Justice Narayan Chandra Shil, a former judge of this court, as the sole arbitrator to resolve the dispute between the parties, subject to obtaining declarations to consent from him under section 12. Allowed হয়ে আছে আচ্ছা তাহলে AP number such and such is allowed না বলে AP number such and such, comma, which already stood allowed, comma, but some order has to be passed on a computer. এতে ঢুকবে না তো তাহলে এটার জন্য অ্যাপ্লিকেশনের ব্যবস্থা করতে হবে একটা ফর্মাল তাহলে AP number such and such না করে hence instead of last line hence instead of the previously appointed arbitrator, namely Mr. Ashish Sikdar, ASISH SIKDER, comma, Justice Narayan Chandra Shil, a former judge of this court, is Maketa Center. They appointed as the sole arbitrator to resolve the dispute between parties. একটা লাইন অ্যাড করে দিন, since AP number such and such has already been disposed of previously, comma, no further order need be passed disposing of the said application. New motions, item number 2, DCS Limited versus
Item number 2 to 4, ma'am, praying for short passover, ma'am.
Pass over. In the first call, pass over.
Item number 3,
Same. 1 to 4.
2 to 4, my lord.
2 to 4.
Yes.
Item number 5, Mongol Electrical Industries Private Limited versus Andrew Yule and Company Limited.
To appear for the petition in this matter, my lord.
My lord, in this matter, I'm appearing for the respondent, my lord. I received the copy on the on Friday, my lord. I immediately forwarded to the client. Since the Saturday and Sunday was closed, I was just seeking just 3, 4, 5 days, my lord, time to get the instruction, my lord.
On the prayer of learned counsel for the respondent, The matter is adjourned till May 2, 2023. Second.
Deeply obliged, my lord. Deeply obliged.
Second May. Second May.
Item number 6, Nupur Modak.
Yes. Petitioner.
Petition.
Good service on the respondent.
Yes.
Last-
On
Lordship,
the
I
last
have
occasion,
for the, I'm praying for short passover, Lordship.
Pass over in the first call. Yes.
Item number 7, Sri Solai Malai P. Anand versus Messrs. Exide Industries Limited.
I am opposing this
Opposing.
application, my lord. It's a section 11.
Yes.
Ideally, my lord, I'd like to file an affidavit to this petition.
Lord, may I indicate, my lord? This matter was, my lord, the section 11 application previously was filed before the Calcutta High Court. Withdrawn, filed before the Madras High Court. There is already an order that this Honorable High Court has jurisdiction seat. There they have already filed an affidavit which I've annexed.
Mr. Mitra, what do you want to point out in
Yes.
your, what is your
Yes, I'll tell you,
objection?
Lordship, my lord. Two principal points, my lord. First, my lord, they've clubbed 4 agreements together, which is impermissible, my lord, insofar as an arbitration is concerned. 4 agreements.
Invocation was common.
I'm sorry, my lord.
Invocation was
No,
common.
invocation by one letter under section 21.
Common. Yes.
So not permissible. 4 separate agreements, 4 separate causes of action. Causes of action arise in 4 separate cities. So a joinder, my lord.
How soon can you file your opposition, sir?
Lord, may I
Short
indicate
point.
this?
Yes, my lord. And also,
If it
my
is-
lord, I'll just indicate to my learned friend, also, my lord, the issue of limitation. It's a stale claim,
All questions should be
2014.
open, but
Yes,
how
my lord.
soon can you file your opposition? Section 11.
Lord, may I-
Two
may I-
weeks, my lord. 2 weeks.
May
my
I
lord,
only
to-
indicate this, my lord? If it is the only contention, my lord, as far as the limitation is concerned, my lord knows it has to be decided by the tribunal.
Unless it is palpably especially
Yes.
clear.
I bow down to lordship. Other than that, if it is my learned senior friend's argument that there are 4 separate agreements, I leave it to your lordship, my lord. They will appoint one arbitrator for the 4.
Invocation
That is
becomes
also-
bad.
Invocation becomes bad. my
That
lord.
very well. They will argue that.
Because then it's not maintainable. You have to
Correct.
start afresh.
Correct.
If I hold against you.
Very well. If they want to
On the
take-
prayer of learned counsel for the respondent is directed to file an affidavit in opposition within a fortnight from date, full stop. Reply, if any, shall be filed within 3
1
days. Reply, if any, shall be filed within a week thereafter, full stop. The matter shall be listed next on May 18, 2023. 18th May.
Grateful. my lord.
Adjourn motion, item number 8. Torun Palibal.
I am for the respondent, my lord.
Respondent, you are for the, yes, Mr. Mukherjee.
Started the argument, but I'll just. But if your lordship takes. My section 11 application, they are alleging there was existence of fraud in execution of the agreement. Therefore, they are challenging the existence of the document in their affidavit in opposition. That's the point they've taken. My lord, may I just show your lordship what has happened, my lord? If your lordship takes their affidavit, my lord, takes the petition first, my lord.
Opposition and reply. And that's it.
This was, my lord. Here
No
the
reply, you are not filing any reply, Mr.
transaction- File a reply.
Mukherjee. Yes.
My lord, I'll now have understood. My lord, the affidavit in reply is coming from Delhi. It's on transit. We have a copy. We are ready with the matter. I
We
can
can
file it.
proceed with that, but provided you
I will
file.
file it within 2 days, my lord. It's on the
Very
way.
well, one copy will be kept on record.
This is the
You have
copy.
served on the other side.
I've served on that.
Very, yes, we can proceed. Right,
Sorry, I thought it is been filed. I didn't.
yes, yes.
Well, this is a application where I was an employee. My employment was terminated.
Hmm.
So according to me, I have some monies which is due and payable. So I have made a claim for return of that money, the money which I'm entitled to. There was an employment contract. Employment contract has a arbitration clause. So I have invoked the arbitration clause. The respondent, the case they have made out that before the employment contract, there was a employment letter, offer letter. That offer letter does not have any arbitration clause, and there was only that offer letter and there is no employment contract. Employment contract has, according to them, been manufactured, and I, being in a high position in the office, being the CEO, I had a influence over my juniors, and I got this employment contract executed by my juniors. And they've taken these two other points, that the junior, the person who has signed the employment contract on behalf of the respondent company, that person was not authorized to sign the contract, and that person was under my influence, so he signed the contract, if at all. So execution of the contract itself is not being disputed by the respondent. What they are disputing is whether the person who had signed it had the authority to sign it or not. Now, my lord, they have taken criminal proceedings. They have initiated criminal.
They are a company.
They are a respondent of the company. I was an employee. My services had been terminated.
Yes.
Now, the point they have taken now, apart from these allegations of fraud which have been taken up for the first time in the affidavit opposition, they have initiated criminal proceedings against me. Now, after I issued the Section 21 notice,
Yes.
they filed a criminal complaint in Delhi alleging that I have siphoned out some money from the accounts of the company.
There is a second complaint.
My lord?
That is a second complaint.
Yes, the respondent company. The respondent has said that during my tenure in the respondent company,
Yes.
I have taken out some money, around 11 odd lakhs, and therefore that's a
Previously, you said there was another criminal case, or that is the only?
that is the first criminal case I knew of. Now, in the affidavit in opposition, I find that after I filed the Section 11,
Yes.
they have initiated a second complaint.
Very
FIR, that copy is not annexed. I have not been served with a copy. So I've come to learn that's about it. In the first criminal complaint which they had filed, there is no allegation that this employment contract has been fraudulently signed, or there is any forgery, or or signed under any undue influence. All that criminal complaint which was filed initially is only about an allegation that I have siphoned out 11 odd lakhs from the company's coffers.
That's on a different foot.
That's on a different footing. So the initial complaint which was filed, there is no allegation of fraud.
But in the Delhi complaint, that is there.
In the second complaint, I don't know. Second complaint, there is reference in the affidavit in opposition that a new complaint has been filed sometime in March 23.
They've indicated on what ground?
No, my lord. I can find it from the above.
So that
but
is the
in
objection.
In the affidavit, the case which has been made out, as I said,
Fraud.
is that there is a fraud. So I have to show from my front whether they have been able to show there is manifest non-existence of the contract or not. If I can show it is not there, then it has to be referred to arbitration. My lord, should I show the law which is there first, and then, my lord, I'll place the law first.
Yes.
My lord, your lordship has knows, my lord, Vidya Drolia. My lord,
Yes,
I
by
have
now,
to cite it. I have to cite it. So, my
No,
lord, therefore, a
definitely, why
copy, my lord.
Yes.
I don't want to show too many paragraphs of this, my lord, only 2 paragraphs. If your lordship takes as to in the reference point in
Yes.
Section 11, what will be the test? My lord, if your lordship takes paragraph 154, my lord, this is a part of the judgment of Justice Khanna.
Yes, yes.
I don't want to go through the entire judgment. Your lordship has seen it. My lord, page 1, para 154.4 at page 121.
Yes.
Rarely as a demurrer, the court may interfere at Section 8 or Section 11 stage when it is manifestly and expressly certain that the arbitration agreement is non-existent. So that is the test. Invalid or disputes are non-arbitrable, though the nature and facet of non-arbitrability would to some extent determine the level and nature of judicial scrutiny. The restricted and limited review is to check and protect parties from being forced to arbitrate when the matter is demonstrably non-arbitrable, and to cut off dead wood. The court by default would refer a matter when contentions relating to non-arbitrability are plainly arguable, when consideration in summary proceedings would be insufficient and inconclusive, when facts are contested, when party opposing arbitration adopts delaying tactics, impairs conduct of arbitration proceeding. According to me, it falls under these categories. This is not the stage for the court to enter into a mini trial or elaborate review so as to usurp the jurisdiction of the arbitral tribunal, but to affirm and uphold the integrity and efficacy of the arbitration as an alternative dispute resolution mechanism. And I also rely on the last paragraph 244. Well, but I'm not reading it out. I'm sure, my lord, it has been placed to your lordship on several occasions as to what the tests are. Well, at NN Global also, I want to show just 2 paragraphs, not the entirety. In fact, only 1 paragraph, para 39.10. At page 429. In a recent judgment delivered in Avitel Post Studios versus HSBC, Mauritius, which pertains to international commercial contract, the issue of arbitrability of fraud arose for consideration. This court held that the same set of facts may have civil as well as criminal consequences. If it is clear that a civil dispute involves question of fraud, misrepresentation, etc., which can be subject matter of a proceeding under Section 17 of the Contract Act 1972 and a tort of deceit, the mere fact that criminal proceeding can or have been instituted in respect of the same subject matter would not lead to the conclusion that the dispute which is otherwise arbitrable ceases to be so. And now, my lord, the last judgment, I don't want to repeat, my lord. My lord, one of your lordship's judgment only in Razia Begum. My lord, this has been reported.
These judgments are clear.
My lord,
If on same proposition, don't say.
my lord, I just want to show 2-3 paragraphs because it's opposite to my facts here. My lord, this is. Malad, this has been reported now, Malad. I didn't have a copy, Malad. AI 22, Calcutta 43. It's now been reported. 43. Malad, your lordship has used the words that the fact that there is fraud cannot be used as a magic wand to say that it's not arbitrable.
Must have been borrowed from somewhere.
But it's a word which is very useful, I find, my lord. Because, my lord, what happens now,
Was
my lord,
borrowed actually from some other judgment.
maybe,
I
my lord.
should have given the quotation mark then. May not be, may not
My lord,
be.
my lord, this
Anyway,
case,
right.
there was a partnership deed and there was allegation that the partnership deed was not existent. So, my lord, and there was allegations of fraud and forgery. I'm not going into the facts. Your lordship will see, my lord, at paragraph 28 of the judgment. I had a copy though. I mean, I'm a copy to the My lord, paragraph 28 of the judgment. This was a section 8 application. So there was a plaint and there was a section 8 application. But now, my lord, your lordship knows the tests in section 8 and 11 are identical.
Yes.
So, my lord, para 28, your lordship will find that the allegations of forgery as made in the plaint is set out. Para 25 of that plaint, my lord, at internal page 9 of the judgment, these allegations of fraud, all particulars are given. Considering all that, my lord, paragraph 30 onwards, I'll show only 2 or 3 paragraphs. A mere glance at the pleadings regarding the alleged fraud shows that it is well within the jurisdiction of an arbitral tribunal to adjudicate the same, since no serious question of fraud requiring evidence at length to be adduced has been raised. The premise of the allegation were based on the ingredients stated in para 25, all of which can be resolved on examination of the impugned deed itself in conjunction with other corroborative evidence if led by the parties. There is no such issue involved in the suit which cannot be decided by the arbitral
There an
tribunal.
additional factor was there, probably, Mr. Mukherjee, that section, since it was section 8, now there are certain things which can be decided by the court also, that prevalent view is also there. Fraud on detail or
Yes, my
whatever.
lord.
Now, for that reason, probably that's indicated here, because from the face of that, but in your case, section 11 is all the more restrictive. In
Yes,
view of
my lord.
NN Global and
But my lord, the Vidya Drolia has now specifically said, my lord,
Vidya is very specific,
very
NN
specific,
Global also
8 and
very
11, 8 and 11, same test, my
It
lord.
is same tests otherwise, but
Otherwise, but
there is a distinction on this.
okay, my lord, I'll
Not identical.
and my lord, then paragraph 31, Vidya Drolia, my lord, your lordship has then considered Vidya Drolia, then NN Global para 32. My lord, I just come straight to paragraph para 37. In fact, the arbitral tribunal has ample power under section 26, 27 respectively to appoint experts and to take assistance of the court in taking evidence if necessary. In view of such wide scope of adjudication and the powers available to the arbitral
So
tribunal.
I found the magic wand.
My para 39.
Yes.
I know, my lord. I wanted to show that paragraph also.
Section 16 and 26 and 27.
26. And para 39 also. So,
39
my lord,
is
just because saying that there is allegation of fraud in the execution of the contract, you can't get away.
Right.
And my lord, reading Vidya Drolia at the reference point, it is for the respondent to show that there is manifest non-existence of the arbitration agreement. And whenever there is a doubt, you have to refer to arbitration. My lord, there is one more judgment. I'm not Justice Saraf's judgment on an identical point where an allegation of fraud was raised. Huh? Oh, there are 3 copies. I just said. বলে দিচ্ছি হ্যাঁ यशवर्धन सिन्हा की না এটা জয়ন্ত চৌরাসিয়া জয়ন্ত চৌরাসিয়া he my lord I my lord para 689 identical I'm not going to place my lord it's identical facts where there was fraud which was alleged and Justice Saraf also holds that just by alleging fraud you can't do away with the arbitration clause. Now my lord the facts here, if your lordship takes the petition, my lord, page 19 is the employment contract. Your lordship sees page 19 is the employment contract.
Yes.
And at this is a contract dated, your lordship will see 20th January 2021. That's where your lordship why. Your lordship sees on the top, employment contract herein after the contract made and entered into on this date, 20th January 2021.
Yes.
Well, at page 35 of this employment of this of the petition, clause 20.1 is the arbitration clause.
Right.
Now, my lord, page 43, your lordship will find is the termination notice which has been given. Page 43. The termination notice does not refer to any employment contract or employment letter. It just says, please be informed, so-and-so has intimated on 13 that it wishes to end the professional relationship between you and the company. At the meeting in Delhi, you're requested to prepare a handover plan and share so-and-so. The meeting, next paragraph. Therefore, please consider this letter as a written notice that the board of the company wishes to terminate your employment with effect from 11th August 2022 and gives you 3 months salary in lieu thereof. This is what is said in the notice. My immediate response is the next page, page 44. I will reply, my lord, page 44, the next day. I will be replying to you shortly with all submissions. Whatever you are doing is harassment, unjust, unfair, retaliatory, discriminatory, and completely arbitrary. Then, my lord, your lordship will take, my lord, page 49, my email dated 1st September 2022. My lord, here, my lord, your lordship will find there's reference to a notice of demand, which is see attached. Thus, this notice of demand is at page 51. This is the first correspondence, proper correspondence after the termination. Well, right at the reference, your lordship will see employment contract dated 20th January, notice of termination dated 11th August 2022 referred. Both are referred. Well, then I make my claim, and in paragraph, the second paragraph, I also give reference to, I'll read it out. You are further put under notice that this is your final chance to make such said payment of rupees so-and-so as remuneration, and you have unlawfully withheld of mine. In terms of clause so and blank, blank, and blank of the employment contract, it is demanded that you make payment of rupees so-and-so. This is the demand that I make. Well, the immediate reply to this is page 53. The first reply, this reply comes from the company itself. 3rd September 2022. We are in receipt of your email dated 25th August 2022. At the outset, the contents of your email letter are inappropriate, factually incorrect, and in completely bad taste. You are forthwith required to withdraw your letter. You are not eligible for payment, any payment, much less the inflated sum of rupees so-and-so as claimed by you. Please note that there is no basis or breakup of how you have arrived at this sum whatsoever, and the same is rejected by the court as untenable. Moreover, the so-called provision clauses you have allegedly have relied on is of no avail.
So they are
As your employment contract.
they are alleging multiple breach of the employment contract,
Yes.
and they're not
They are
disputing
not.
on the
And they
ground of
refer
fraud.
to the employment contract also. This is the
Yes,
first
yes.
response.
Yes,
And they also, my your lordship, multiple breach. Your lordship, as your lordship, right?
yes, yes, you're right.
After this notice, after this reply, I issue a section 21 notice. That, my lord, is at page 54. On 13 September 2022. Well, I'm not going through the notice because there also there's reference to the contract. This, well, there's now a response by a lawyer. Well, at page 58, 11th October 2022. Well, I will take your lordship, well, straight to the point. Well, at page 59, the third paragraph. At the threshold, it is stated that the notice issued by you is improper and not in terms of the Arbitration Conciliation Act. Moreover, your invocation of the arbitration clause has been erroneous with complete disregard to the provisions contained in the employment contract. For this reason alone, the invocation of notice is liable to be rejected at the outset. Without prejudice to the foregoing paragraph, para-wise response to the averments made by you is as follows. Now, para A, my lord. The contents of para 1 and 2 of the notice need no reply as they are matter of record. The purported clauses sought to be relied upon by you in the employment contract dated 20th January 2021 are denied as being non-existent, and you are put to strict proof of the same. It is stated that there exists no arbitration agreement in the employment letter dated 29 December 2020, by which your client was appointed and which was duly acknowledged by him. Fabrication of any document, if done by your client, would be at the sole risk and responsibility of your client. So this is the point they take. I file my section. Now, in between this, my lord, they filed a complaint. In that complaint, their only allegation your lordship will find from the affidavit in opposition is siphoning off an alleged 11.5 lakhs and nothing else in that complaint. Now comes my section 11.
That was lodged subsequent to claim.
Subsequent to the demand notice. First, my lord, when the termination happens, they say they will pay me 3 months salary. I make my demand of my salary and all my other outstandings. Then they say, no, nothing is payable by you in terms of the arbitration clause. I issue a section 21 notice. They rely on the employment contract, but say there is no existence of the arbitration clause in the employment contract. Now comes, my lord, their affidavit in opposition. Filed now, my lord, I file my section 11. Then my lord, affidavit in opposition has been filed on 15th April 2023. In between this, there is also section 9, which I had filed before the Alipur court, from which they preferred an appeal. In the memorandum of appeal also, no ground taken that there is no existence of an arbitration clause. They say the order could not have been passed because the order was in the nature of an order 38 rule 5. And order 38 rule 5 order could not have been passed. The appeal, but my order has been set aside only on the ground there was no reasons in the order. Not for any other. The appeal was taken up last week. Only reason for setting aside that order, my lord, is that there was no reasons given in the order. And it was remanded back so that it can be heard afresh on interim order. Nothing else. So in the memorandum of appeal, no ground taken. There is no existence of the arbitration clause. In the affidavit in opposition now filed, my lord, your lordship will take, my lord, only 2 paragraphs. My lord, para 5. This is the first time they are actually going, they made out their case of fabrication. My lord, affidavit of para 5. The respondent company works in the field of development and works towards setting up of solar grids in rural areas to enable population in these areas to have access to clean cooking and electricity. The present matter involves serious allegations of fraud and fabrication by the petitioner. My lord, the term raised from Alaswamy, my lord, the Justice Chandrachud's judgment, owing to which it is not possible for this court to proceed with the appointment of an arbitrator without deciding the said issue related to the very validity and existence of the arbitration agreement. Moreover, the validity of the alleged employment contract dated 20th January is in question. It becomes a jurisdictional issue, and unless there is a valid arbitration agreement, the application under section 11 will not be maintainable, and it is the Honorable Chief Justice or his designate to decide the jurisdictional issue. Therefore, the question raised in the present reply to the extent as to whether there is any arbitration agreement, the same must be decided by the Honorable Chief Justice or his designate. Then, my lord, para 7, Roman 1. These are the allegations made. The present application has been filed under section 11 for appointment of a sole arbiter on the basis of a self-created forged document without any mutually agreed terms having an arbitration clause. The alleged forged employment contract has been forged by the petitioner in order to create unfair forged terms and the conditions against the respondent company and in favor of the petitioner for unjust enrichment. The said act was committed by the petitioner in the garb of creating standard employment contracts for existing and new employees, whereas while working towards the creation of standard templates for the rest of the employees, the petitioner created a different document for himself, and hence the agreement is nothing but a perpetuation of fraud. My lord, then your lordship will see, my lord, Roman 2. Allegation is made that Anirudh Bakshi, who has signed the agreement, was not author, my lord, para Roman 4. It is submitted owing to his position in the respondent company. He had significant influence and command over his employees under him, and as such was a top official with no personnel above his stature in the respondent company in India. And then, my lord, there's one more paragraph where, my lord, they say that the person who has signed it, this Anirudh Bakshi, my lord, Roman 18 at page 10. That on internal inquiry conducted by the respondent company, it came to the light that the petitioner took over the HR department in December 2021 when Anirudh Bakshi was still in active employment of the respondent and assumed charge of the same, and all documents were in exclusive custody of the petitioner himself, despite requisite personnel being appointed for the said post. The said act was done by the petitioner since his authority over the employees in India was unquestionable, owing to a position he held over the confidence over the board of the company, which was a position of power. Anirudh Bakshi, by signing the non-disclosure of the aforementioned facts, facilitated creation, forging of the document. So, and my lord, at also, my lord, page 12 top. This is the other allegation.
No authority.
No authority of Anirudh Bakshi to execute the alleged employment contract. Now, my lord, your lordship, now they have relied, my lord, in this document, in this affidavit, my lord, to the employment letter which was given. My lord, page 19, your lordship will find is the email at the bottom dated 29th December 2020 by Anirudh Bakshi. We are pleased to offer you the position of General Manager with HON'BLE India Sustainable Environment Private Limited. The offer letter is attached herewith for your perusal. The next line. Duly signed contract shall be given to you on your date of reporting. That is 20th January 2021.
We cannot go into this question so much.
All I'm saying, my lord,
They have
even
not
by
even-
their documents, my
So
lord.
they did not produce any alternative document.
No, nothing.
They
Nothing
do that in the arbitration.
Let them do it in the arbitration, absolutely. And my lord, most importantly, your lordship will see page 21. This is the offer letter, which they are saying is the only existing document. Offer letter, my lord, has been signed by the same Anirudh Bakshi.
It appears that your arguments before the arbitrator will be over very soon.
I suppose so, my lord. So, my lord,
Mr. Banerjee.
so, my lord, these are the facts.
Yes,
And my lord, they've only one last thing, my lord, your lordship will see. They have now referred to the new criminal case, my lord, at page 9. My lord, page 8, Roman 13 is reference to the police complaint which I mentioned, my lord. Your lordship will find it's a complaint dated 4th October 2022. In that, my lord, there was only offenses of cheating, misappropriation, and criminal breach of trust, which was at 11.5 lakhs. Copy of the complaint is also annexed. And Roman 15 is the new complaint which has been filed. That the complainant has filed an application under section 156(3) for registration of FIR, which has been registered at so-and-so, dated 4th March 22, which is pending adjudication. Copy has not been annexed. I don't know what has been mentioned there. So far as the first complaint, there was no reference of any allegation of fraud.
Yes, Mr. Banerjee.
No, my lord, my lawyer friend started with the judgments, my lord.
Oh, my lord,
I'm-
my lord, one last thing. My lord, if your lordship takes page 37, well, they were aware that there is existence or that they can raise an issue of the alleged of allegation of fraud. Well, at page 37, this is part of the complaint, para 20. Mr. Paliwal has also purported to issue a further notice dated 21st September through his advocate, allegedly under clause 20.6 of the employment agreement as advance payment. So they refer to the arbitration clause also, my lord. In the complaint, they were aware of it. They could have taken that point. They don't take that point. So, my lord, I was relying on this, my lord, to show also on that Vidyadrolia, that, my lord, the paragraph I showed, para 154.
So this may not
dilatory
tantamount to admission of the agreement.
My lord, but
Paragraph
dilatory all I'm saying
Allegedly
is they
under
were
clause-
aware of the existence. They don't
Too many
challenge.
alleges. Too many.
There's no allegation that there is fraud. They are referring to
That
the
is
clause.
not there.
I'm not on that front.
Definitely not.
The first time they raise an issue of fraud
Not there.
is first in that reply notice, and now 15th April. That's all I was trying to say. So, my dilatory tactics adopted to delay arbitration proceeding, which also should not be appreciated for that. Obliged.
Now, my lord, my lawyer friend has relied upon the judgment of the Vidyadrolia, in which, my lord, the elaborate tests have been laid down. How far, my lord, the section 11 court can inquire into, my lord, the arbitration agreement. Now, my lord, this judgment has been subsequently considered. My friend, my lord, cited this judgment on the last occasion, NTPC versus SMPL. There the crux of the judgment of Vidyat Rolia has been, my lord, laid down, has been, my lord, summarized. It says, my lord, that only a prima facie test, prima facie review can be taken up by the Section 11 court. Not that Section 11 court will not at all go into it, but it shall be a prima facie, not a minute trial, but a prima facie review of the documents to see whether there is existence, whether there is prima facie forgery or not, only to that extent. Now, I'm not taking cue from this. I'll just place the paragraphs, my lord. Paragraph 25, 2 onwards, my lord. 22, 154.4 is quoted, which also says, my lord, rarely as a demurrer.
Quotations.
Lord, she will kindly come to page 20, paragraph 22.
Eye of the needle. Let us come to the eye of the needle.
No, before that, Lord, 154.4. 154.4 minute has been
That is quoted from Vidyat.
quoted from Vidyat Rolia. Yes.
154.
And Lord, then what is Lord prima facie test? That is also not considered in Lord paragraph.
It has to be palpably, especially clear, Mr. Banerjee.
Paragraph 23. What is, yes, I'll show palpably, especially what they have done is a class act of forgery. I'll show from the documents itself. Right now, I'll show.
And I'll decide that in section 11.
No, but if there's a prima facie case made out, then your lordship will not consider whether it will lordship.
Prima facie. Ex facie.
I'll show
Prima facie.
ex facie. I'll show, my lord.
And show me that prima facie portion, Mr. Banerjee. You were relying on something.
Lord, paragraph 22 quotes 154.4, then 23. The limited scope of judicial scrutiny at the pre-referral stage is navigated through the test of a prima facie review. This is explained as under. Prima facie case in the context of section 8 is not to be confused with the merits of the case put up by the parties, which has to be established before the arbitral tribunal. It is restricted to the subject matter of the suit being prima facie arbitrable under a valid arbitration agreement. Prima facie case means that the assertions on these aspects are bona fide. When read with the principles of separation and competence, section 34 of the Arbitration Act, referral court without getting bogged down with would compel the parties to abide unless there are good and substantial reasons to the contrary. So I have to show not from the documents ex facie that there is something which shows that there is non-existence of the agreement. Now kindly will not allow me to not show from the documents itself. Not what he has shown not only the tip of the iceberg.
What about the other judgment, Justice Sharaf's judgment?
But everything is relying on Vidyat Rolia and subsequently SMPL. Everywhere.
I have given a copy.
It has been handed over.
I have
Handed over, my lord. It doesn't say, my lord, that prima facie cannot be done. Prima facie inquiry cannot be that. This is not the ratio of this judgment that the court will even not do prima facie inquiry and send it to arbitration. I know, my lord, the scope is very limited.
Respondent. সেজন্য আমার বলেছি আগের দিন মানে এই ম্যাটারে
এটা দিয়েছি তো
কোনটা রে
সব্যসাচী দাগটা
না
এটাও রিলাই করলাম 22 Calcutta.
Yes, please continue. Which
Lord,
page?
the judgment of Lord Honorable Justice Saraf, it doesn't Lord lay down the law that even prima facie inquiry is not contemplated.
Right.
So Lord, I'm only on prima facie review by your lordship, Lord, from the face of the documents. If I can show that not some forgery has been done by him, then your lordship will consider whether your lordship will send it to arbitration or not. Now, kindly see, my lord, the appointment was given in 29th December 2020. They have not annexed that, my lord. I have annexed that page 19 of my affidavit in opposition. My learned friend just placed it, my lord. Page 19 of the opposition. Annexure A is the email, my lord, dated 29th of December, which is accepted by him on 31st of December. Now, my lord, this, my lord, annexure, this contains, my lord, the offer letter, which, my lord, as per us, is the terms of employment. Now, my lord, clause 2 is termination, which says 3 months notice. We have invoked this clause. So, my lord, this is the, my lord, first document which goes to him from the company. Now, my lord, and kindly see his designation, my lord. His designation is general manager. This is very important because after this, my lord, he requested the company that you change my designation to CEO.
Mr. Banerjee, do you want to argue that it should be a prima facie presumption that all general managers are cheats?
No. But in this case,
that is the only thing.
I'll show.
Others, how can you say it's ex facie?
Ex facie, kindly allow me to.
It's very arguable on facts. Very arguable on facts. He was general manager. He had control and all these things.
No, not on that, my lord. I'm not on general manager or his control. I am on, my lord. This document designates him as a general manager. In March, my lord, he writes.
For me, ex facie, Mr. Banerjee, without arguments.
I'll show just 3 documents. In March, then kindly comes, my lord, to his letter of March, which is at page 75.
Of the opposition?
Of the opposition.
Yes.
His mail to us, my lord. He says, as desired, gist of this email is that MSCPL being the private limited company, as per law, there is no requirement for a key management personnel, that is manager. Hence, it is not at all required to do a board resolution to make me a manager first, and then do another board resolution to change the title to CEO, because he was pasted 5 minutes. I kindly give you 5 minutes.
Take 10 minutes, 15 minutes,
I'll
half
just
an
go.
hour.
It is
I
not-
don't have any difficulty. But Mr. Banerjee, this is irrelevant.
It is not.
Should I go into this?
It is not because
I cannot assess evidence.
I know.
Section 11.
I'm not
Even the
regarding lordship.
arbitrator could not consider this without being proved in some manner or the other. That I'll go into the documents.
No, I'm not. I'm not.
This may be
requesting
a
your lordship to assess
document.
the evidentiary value. I am only showing my lord that in this letter in March, he is requesting us to change his designation in the offer
Who
letter.
knows whether it's written by him
And-
or your printout? Who knows? Who can say that? You have to
But
prove it
The
formally.
reply he
before a
has
court
not
of law or
disputed.
an-
I know, my lord. He has not disputed. Now, my lord, the question is, he has relied upon an employment contract
Yes.
of January 2020, in which his designation has been given as, my lord, CEO. And in the subsequent date, he is pestering the company that kindly change my designation from general manager to CEO and make that change in the employment letter. That is his letter in March. How can he antedate it, my
Banerjee,
lord?
these require assessment of the evidence because in football teams and in corporate sector, one has to do many jobs, has to wear many hats rather, if I can use that expression. So one does not know a CEO may be designated in some other post, general manager. These are interchangeable.
No,
Mr.
I am not on his designation. I say, my lord, that in March, his request the
Maybe
company.
he was it was given out to him he would be a CEO, and subsequently he said no. There was
No, it
negotiations.
was-
Maybe how do we know at this stage?
The prima facie review then becomes meaningless, my lord, unless your lordship, my lord,
I'll give some meaning to it. I'll save the Supreme Court on this.
because, my
Say
lord,
that's
the
meaningless. I'll
documents-
give some attributes.
the
of meaning.
documents are to be, my lord, at least, my lord, looked into prima facie to see what he has done. In March, he is asking us, my lord,
What do
to.
you mean by prima facie exactly?
My lord,
And what is the
documents-
difference between prima
documents
facie
on
and
the
ex
face of
facie?
it.
What is the difference between prima facie and ex facie? There cannot be prima facie ex facie, Mr. Banerjee. There cannot be prima facie ex facie. These are mutually exclusive. If it's ex facie, cannot be prima facie. It has to be clinching, conclusive on the face of the document. There cannot be something which is prima facie ex facie. These do not go together. If it's ex facie, cannot be prima facie. It has to be conclusive on the face of it. So this prima facie review is not on whether there is an ex facie bar, or maybe even that.
No, there's no explicit bar at
That
all,
is
my
the
lord.
prima facie review, Mr.
It is
Banerjee.
not an
That's the
explicit bar.
There are two layers to this. I'll prima facie review in section 11 whether there is an ex facie bar. There are two different layers, two strata. These cannot be confused together or fused together, if you so say.
Kindly, my lord, keep this question open. I'll take up with the arbitrator, my lord, because
No,
evidence
I'll
is a
decide
question of
this. Since you have invoked the section 11 jurisdiction to decide this, I'll decide this.
on this. Then, my lord, kindly,
Ex facie, there is no bar that I'll have to say.
ex facie bar, my lord.
Or
the
ex facie
document-
fraud
in the
is not
document-
established. That I'll have to say. That's your point.
Then, my lord, if your lordship deciding on ex facie, my lord, I'll just show, my lord, two documents. This letter, which is dated, my lord, 26th of March 2021, by which he is saying he's referring to his offer letter.
Yes.
He's saying he's not referring to an employment contract, because at that point of time, my lord, the fraud had not crossed his mind. There was no employment contract at that point of time. He says, kindly make a change. His solution is that just revise my appointment letter by changing the designation from general manager to chief executive officer. In any case, I have not yet received the hard copy of the earlier one. So, my lord, he has not received the hard copy of the appointment letter, which is page 19. He says that in that you make a change and make this general manager to chief executive officer. Now, let kindly see the employment letter that he is relying upon. That is not the first annexure to the section 11. What is the date of that? This is, Lord, at page 19, employment contract, in which he is described position as chief executive officer and executed in January 2020. So, Lord, in March, in January, his employment contract is entered into by designating him as CEO. And in March, he's writing a letter to the company that kindly change my designation in my appointment letter from general manager to CEO. This is not ex facie, my lord. He has this is
What is
antedated.
the appointment letter again, Mr. Banerjee?
Appointment letter, my lord,
Just let us see that once.
kindly comes to page 19 of the opposition.
Yes.
Page 19 of the opposition, annexure A, the email at the bottom dated 29th December 2020.
And that letter of yours?
And that letter is, my lord, page 21. This contains a termination clause but doesn't contain any arbitration agreement. Then, my lord, he writes to us,
One
my
second.
lord,
Page 21.
page 21. This is the appointment letter.
No, where is
Offer
his letter? His letter.
He's relying upon
He
that.
said something changed from CEO to
Yes,
general manager.
his letter is not at page 75 of the opposition.
That is what.
Page 75,
Yes, sir.
he requests the company that just revise my appointment letter, fastest solution. Just revise my appointment letter by changing the designation from general manager to chief executive officer. This is dated 26th
Let
of
us
March.
see your appointment letter. Yes.
Yes.
His appointment.
Appointment at page 19 designates him as the general manager. He requests, so far there is no forgery. Then, my lord, this is the previous mails, my lord, the company considers whether it
No,
can be
Mr.
changed.
Banerjee, 1 second. Give me half a second. Page 19 is the offer letter, the
Offer letter.
appointment letter or whatever you say. There it was stated, I am very pleased to accept the position of general manager.
Yes.
So that's the reply actually.
Yes. Then he approaches the company in March. This is in December 2000.
No, your offer was general manager in
Offer of general
in
manager,
that
yes.
letter.
Yes.
Subsequently, when you handed over the employment contract, it was seen there.
No, this
Suppose there was an employment contract, which you say is not there. We have to suppose too many things. Why I tell you, suppose there was an employment contract subsequently. There you describe him as a CEO.
as CEO.
And he now says, rectify my appointment letter. There is discrepancy.
No, that
between
is not the that is
that
not,
although proves there is a contract.
that
His
is, that is
letter.
not the request.
You are saying that this letter exists. Page 75.
Page 75, yes, it
That
exists.
shows the existence of a contract.
No. It shows me, Lord.
Mr. Banerjee, why I tell you? In the contract, it's written only the contract. The contract is the only document.
Does not refer to
Mr. Banerjee, the contract is the only document where we find that there is a mention of CEO.
Yes.
That is the only document.
Yes.
His appointment letter says general manager.
General
What
manager.
was the occasion to write this letter? Change it from general manager to CEO. Change the appointment letter.
Because he requested the company.
Because there was a contract in between which said CEO.
It is not a fact, Lord. Kindly see the sequence of events, Lord. After this, Lord.
I'm only showing you the sequence of events. You cannot go on facts. It all the more shows there was a contract. Where it was mentioned CEO,
Lord,
there would have discrepancy between the two. It all the more shows it.
Then there would have been reference to that contract. In this letter, had there been a reference to the contract,
Why
he
should
could have
he?
said.
He's
Otherwise, how
treated as
can
a CEO. His appointment, his contract is of a CEO, but he's being dealt with as a general manager for certain purposes which suits you, the company. That's why he wrote, yes, treat me as a CEO, not a general manager.
That is not the letter, my lord. That is not the
Read
letter.
the letter
He
once.
is giving, yes. As desired, gist of this email is that MSPL being private limited company, as per law, there is no requirement for a key management post, management personnel, that is manager, etc.
Yes.
Hence, it is not at all required to do a board resolution to make me a manager first, and then do another board resolution to change the title to CEO. So we are.
So it was on the anvil.
There was a representation
From
from
manager to CEO, it was on the anvil. This letter only says that is not board resolution is not necessary for that.
Yes,
But there was previously some move to change from manager to CEO,
before doing that, contract cannot be entered into, my lord. Before doing this, following these steps, how can a contract be entered into, my lord? Unless the board resolves that he becomes a manager, then he becomes a CEO. The board is the highest authority of the company. Before a board resolution, how can a contract be entered into? That is my point. That
if you want, I can decide that question also from here. I'll definitely do that if you argue. You have argued. In fact, I have to decide. So argue better, Mr. Banerjee.
Then not kindly.
Because I'll render a finding on this. You've argued specifically, and despite repeatedly saying if this is prior facie review, I'll prior facie give certain findings. Definitely, I'm not threatening you, Mr. Banerjee.
No,
satisfy me on the facts, especially that there is ex facie bar, and also satisfy me, Mr. Banerjee, that there can be some prior facie, ex facie, something, whatever. How can an ex facie thing be prior facie? Tell me.
Now, my point is very limited. Lord. This letter,
it is not very limited. It's very elaborate, and then
yes.
You are relying on 3 documents. I'll refer to the documents definitely. But one is page 75.
Page 75 is not the email.
Yes. You are showing the discrepancy between 19 and 75.
Yes. Then we will kindly see the employment contract. All the documents are sent to him by electronic email.
Yes.
Now kindly come to his section 11 application. Kindly comes to page 15. Kindly see when this employment contract is forwarded to him.
Yes. When?
Page 15, top middle, 29 June 2022. So there was no contract forwarded to him before that. Kindly see what happened. He requested his employee, this Anirudh Poddar, that you digitize all the documents and send to me. In reply, he digitizes the documents and attaches them.
Please read it out.
Kindly will not see the
Here, sir. from
mail
this-
bottom. No, not that
No,
one.
no, read that also.
29.
That is the entire email.
Yes, the first email is 29th of June, bottom Millard, 16th at Millard 412, which is written by Mr. Paliwal to Rajiv Poddar. I hope the digitization of all the
Both are
documents in Kolkata.
29th June, Mr.
Yes.
Banerjee.
Both are 29th June.
Yes.
This is the first mail. In reply, Millard, the top one. So the bottom one is the first one. The time is not 1612. The other one is 1524.
In some different country, probably.
No. Mr. Paliwal writes a letter to his subordinate.
Paliwal writes from here.
Yes. So Anirudh is also in India. He's also in India. He's in Delhi. He writes to Millard, Kolkata office. The letter is, I hope the digitization of all the documents in Kolkata
This
office
is a
is going
fancy
on.
corporate thing. Mr. Banerjee, this 16, 12, 34 plus 5:30, 5 hours at Greenwich Mean Time. That's a fancy thing.
5:30 plus 5:30 is not plus. The
Obviously, I
standard-
understand plus
standard
5:30.
GMT plus. So Millard, he writes, I hope the digitization of all the documents in Kolkata office is going on. Can you please share the digitized scanned copy of my confirmation letter and my employment contract to update my records? In reply, the mail, same day, 29th June,
Yes.
as requested by you, please find attached your confirmation letter and employment contract letter to update your records. So for the first time, this document is sent to him by mail on 29th of June, 2022.
The digitized copy is sent for the first
Yes,
time.
copy is digitized and sent to him. There is no communication from the company before that. So the employment contract for the first time it is mailed to him on 29th of June. There is no existence before that, because
Mr. Banerjee,
if the company
did not
appoints
read
him,
so much into this. He asks for a digitized
Copy,
stroke
yes.
scanned copy of his confirmation letter and employment contract to update his own record.
own records.
To
And the-
update means there is already something. He is trying to
So there-
update that.
So there has to be then this document sent to him. This employment contract has to be sent to
Why
him.
you say for the first time it was sent after this? There I'm rather disputing that.
They have not disclosed how this employment contract was mailed to him. by
That's
the
why it's
company.
especially it's a forgery. The employment
The
contract.
entire sequence of events, Millard, because the contract was not signed by us,
Look
not
into the
authorized by the
sequence of
board.
events by looking into 3 documents at the section 11 stage. Mr. Banerjee, I'll impose costs on your client for resisting this on these grounds. I'm actually being clear. I'm giving you warning. You just satisfy me. Why shouldn't I?
Millard, these are the documents I rely upon, Millard. That first, Millard, that
So
this
your
document
reliance is,
was
he is absolutely correct in saying that this is just a dilatory tactic, which falls also within one of the clauses of Justice Narasimha's judgment, Justice Chandrachud's judgment.
Millard, three
Absolutely.
criminal cases are pending against
The
him.
difficulty is I cannot decide the dispose of the matter here and now because I'll have to refer to all the judgments. So, but argue to your heart's length, Mr. Banerjee, because my findings will be against you till now, unless you satisfy me otherwise.
So Millard, the first document I rely upon is Millard, the
3 documents you're relying on. Let me be clear on that.
first is page 19, which is
Opposition, page 1975.
75,
And
19,
And the section 11 application, page 15.
page 15, which is the Millard document which is sent to him
Yes, yes, definitely.
from the company for the first time. Now,
Right.
Millard, page 75, I have shown you to your lordship, Millard.
Hmm.
Page 75, Millard, is his request to the company to change his designation to CEO.
Hmm.
And the previous mails are, Millard, the discussion between the directors, whether at all the post can be changed from general manager to CEO or not. So, Millard, these Millard, discussions which take place
Hmm.
are of Millard, August. So till August, Millard, there is no decision of the board of directors that his designation shall be changed from general manager to CEO. These are the documents we have annexed. And the request of March 2021.
Hmm.
This Millard read with this document at page 19 of his section 11, Millard, the employment contract, which designates him as chief executive officer, Millard, expressly shows that without Millard, the company's directors, Millard, taking a decision that he shall be designated as CEO, this employment contract could not have been Millard, executed. Because Millard, the contract can be executed between a company and a Millard, employee if the board Millard, decides to that effect. I've shown Millard, page 75. The previous mails also Millard, is a correspondence between the directors. Whether Millard, at all it can be done or not. Kindly see the Millard, previous mails. Page 73. Starts from 72, Millard. One of the directors, he says that yes, it can be done. I think the post of CEO can be given to him. And the other director says that there's no need of that. This discussion and ultimately, Millard, the last mail is not at page 72, Millard, 8th of August, by which they say, my lord, 8th of August, they say, so I will go ahead and change Tarun's title to Chief Executive Officer. Similarly, you should make the offer to Avinash to change his title if he wishes. So ultimately, the decision to change his title to CEO comes in August 2020.
Still Paliwal.
Yes, Mr. Pariwal.
Designation was changed.
Yes, designation changes. Designation, my lord, to CEO comes for the first time in August 2021.
Right.
On the basis of his request, my lord, at page 75, March. So, my lord, the employment contract at page 19, my lord, which says him as a, my lord, Chief Executive Officer, this document itself not is subject to question. Questionable. This, my lord, and the other point that he has taken is that, my lord, in my reply, I have not disputed, my lord, his employment contract. He has shown, my lord, some
Yes,
documents.
yes, that is one of the points. No, you have not alleged fraud here, said. He's very
In my
specific
reply, to section 21, fraud has not been alleged. In the reply, my lord, I'll just place my
nowhere
reply.
in the initial complaint, in the second complaint.
The second complaint I have
Second
alleged.
complaint you must have.
Second
Yes.
complaint I have alleged.
Delhi complaint you must
Initial one, my lord,
have.
because,
Very
my
well
lord,
in your reply. Show me that.
initial one, my lord, was regarding defalcation of money, 11.8
It's a different on a
lakhs.
Right.
After that, my lord, the employment contract was for the first time disclosed, my lord, before the section 9 court. Copy was illegible. We applied for a certified copy and obtained the
Mr.
certified.
Banerjee, this Delhi complaint was lodged after section 9 or before?
After section 9, after getting a copy of the section
After
9.
he made the section 9 application, after he made reference to arbitration, after all these two incidents, you made that Delhi complaint.
Yes, after the
That
section
the
9,
document is fraud.
when I got hold of the copy of the contract, for the first time the complaint was lodged regarding, lord, right, this fraud. Because before that the contract was not supplied to us. He refers to a contract, but
Maybe, yes.
so, my lord, these, my lord, regarding the complaint, there are 3 complaints. First one is, my lord, against him for defalcation. Second one is against him, my lord, 156.3 was lodged. Then again another complaint against, my lord, this person who has issued that letter, signed that letter, as well as Mr. Paliwal. Both of them. Last complaint before the, my lord, Sarojini Nagar
Signed
PS.
which letter?
Who has signed, my lord, that alleged employment contract. Your lordship will come to his section 11 application. The employment contract is at page 19. This is signed by, kindly see, my lord, Mr. Anirudh Bakshi, manager HR. So manager HR is entering into the contract on behalf of the directors. The directors have not decided yet whether he will be CEO or not, but he will not signs this contract. And Mr. Paliwal accepts. So this is not a binding contract, my lord, because he had no authority. That question will go to the, my lord, tribunal. But so far as, my lord, this sequence of events, my lord, will clearly show, my lord, that before his resignation as a CEO, the company was considering his request, and the contract is entered into 2001 January, which is not possible. From view of, my lord, time scale also, it is not feasible. So these are the points, my lord. So privacy. So he's saying 156.3 is pending, my lord. That I have stated in my.
You said that.
That's all.
Yes, Mr.
My lord, first reply. This point is not been pleaded. That's why I was taken as a surprise. This point, there is no pleading in the affidavit in opposition.
Which
That's why I
point?
was
Which point?
this argument that
Sequence.
general manager and CEO, there is a change in the reference. This is not pleaded, so that's why I'm taken as a surprise by this argument. Otherwise, I would have certainly found out what is the reason for it. Your lordship will find the only pleading is at page 5, Roman 3, which I did not realize this is the reason for why this pleading has been made. All that is pleaded is that the petitioner was employed by the respondent company at the post of general manager. He was entrusted to oversee and manage the day-to-day work. However, it was suggested by the petitioner that in India, the general manager was not used and only CEO was used. The board of the respondent company, which was primarily composed of persons not residing in India, in good faith accepted his request informally at the best interest of the respondent company, and his designation was changed to CEO subject to approval of the board with no change in terms of his offer letter. No documents annexed here or anything. So I did not know why this reference was being made. My lord, I don't have an answer why this has happened, but what I can see, my lord, that in 29 June 2022, a company's officer has sent these copies to me, and that is what I have annexed here. My lord, I can check this email and see what is there in the email. I have seen that the email contains both the confirmation letter at page 15. It contains both the confirmation letter and the email and the employment contract. I have a copy of that email. And my lord, there is no allegation made against this is the second person, not Abhishek, not Anirudh Bakshi, but one Rajiv Kumar Poddar who has sent it.
This is page.
Page 15, the email which is sent,
What?
which has the employment contract with it. And why this was done, my lord, your lordship will find from page 17. The Calcutta office was being shifted. So all documents were being digitized. My lord, page 17, if your lordship sees, 24 June 2022 of the petition. That is why this email at page 15 was issued. Your lordship will find, as discussed, registered office will be shifted from Kolkata to a new location, most probably in New Delhi, and the process of which being initiated and discussed with the board. This would mean shifting of all material, record, files, documents, etc. In this regard, as discussed in detail, do proper risk management. We will need to digitize all documents presently kept in Kolkata registered office before shifting them to new location. And my lord, the documents which are being done, serial number 2, HR department, employee files, offer letters, employment contracts, confirmation letters, appraisal letters, increment letters, identity documents, PAN, Aadhaar, educational, all. So all these documents were being digitized. That is why I asked for a copy of the digitized document. That is why it was given to me on 29 June 2022. And this is from the respondent company's own email ID. So it's not like, Malad, this has been produced or manufactured by me. If at all I had influence, I had done it, Malad, nothing has been shown for that.
You had influence over Bakshi.
I
Did
but
not
this
have
is a
influence
different
over
man.
Poddar.
Poddar also.
No, not over Poddar.
Not, there's no allegation in the petition.
Poddar is still there in the company.
He's the CEO.
Well, maybe, but that
Having
allegation,
influence over
when you're
everybody, all
making
the
a,
employees.
my lord, when particulars of fraud are being pleaded, my lord, your lordship knows all pleadings of fraud has to be given. In the, first of all, my lord, the entire argument which has been raised today, that in the employment
So
contract,
order
there is
6
CEO.
Wilford does not apply because section 11 is not a judicial adjudication. But especially prior,
Especially they have to show that.
especially part, then I can.
Especially but they had to show it. That has not been showed in the pleadings. If that pleading was given, I would have responded to it accordingly, my lord. My lord, on the face of it, my response is, my lord, on 29th June 2022, when it was forwarded to me, this is the document which I have got. My lord, I can produce both that email also.
Please
On
don't.
record. And my lord, only, and my lord, since this I had already placed, my lord, the 2023 Supreme Court NTPC, para 27, there's one line. If there is any doubt, it has to be referred to arbitration. Just for that. My lord, your
The
para
especially is
27.
without doubt.
Yes, my lord. So there is para 20 page 20, para 27 says, on the other hand, even if there is the slightest doubt, the rule is to refer disputes to arbitration.
If there's a slightest doubt, it cannot be especially.
Yes, my lord. So, my lord, so the point which has been argued right now is not pleaded. Number one. Number two, the document which I have relied upon, this was forwarded to me by the company from a company email ID by a person called Rajiv Poddar. There is no allegation against Rajiv Poddar that he is also influenced by me. When there is a specific allegation against Anirudh Bakshi, contradistinction, they are making a specific allegation that Anirudh Bakshi was not authorized, although it is the same man who signed the employment contract and the employment letter which they are relying upon. On one hand, they say that Anirudh Bakshi is not authorized to sign the employment contract, but he is the same man who has signed the employment letter. So he does not have authority to issue employment contracts, is the allegation. But that is not true. That is not correct, because he himself has signed the employment letter which they are relying upon as the contract. And my lord, finally, the email of which they have only relied on, my lord, the email of 29th December 2022, which refers that a signed contract will be given to me. And most importantly, if there was a second document, they have not relied on that second document. They have not produced it to show that there was something else. There is no dispute. There was an employment contract. What is the employment contract? There is only one document on record. They, being the employer, they should have relied upon. This is not the correct employment contract. That's my answer.
Heard learned counsel for the parties. Judgment is reserved on the present application under section 11. Mr. Banerjee, you tried very well. I must say that. No, I'm not sure. I've not made up my mind. If I did, I would have passed my order right now. So, but apparently against you, against your client.
Much obliged.
Thank you. Thank you. Call on this one.
Item number 9, Mrs. Cementon Engineering versus the General Manager, Eastern Railway.
Yes.
It's my application, my lord. On the last occasion, my lord, I had, my lord, not got a copy of the, my lord, general conditions of contract. Now I have it with me. But I'll just place, my lord, the
I am for the respondent, my lord.
Well, very briefly, I'll not take long. If your lordship kindly takes, this is the petitioner is an A-class contractor under the Eastern Railways. Now, after a tender was notice inviting tender was published, I
First, let me
participated.
ascertain what is the ground of objection. What will be the basic ground of objection so that they can deal with it also.
Main technical fault is that petitioner you should calmly come to my lord, their application for appointing.
Tell me that you will deal with that also.
You should kindly come to my lord, page 55. The divisional delivery manager, senior law officer, but competent authority for application. This my lord, this is general manager. I have my lord, amendment general order my lord, 2019 my lord. You should kindly come. Clause 63(1). All the application.
Reconciliation of disputes. 63.1.
No, my lord. 65.1.
Point 1 is matters finally determined by the railway.
The contractor to general manager. All the application, my lord, refer to the general manager, not my lord, divisional railway manager. He is not the competent authority.
I
Decide all the things, my lord. Number one, my lord. Number two, my lord.
Achha, yes.
Considering the invocation of my lord, clause 64, my lord, GCC, my lord, petitioner are requested to subsection 12.5, my lord. That is, my lord, you should kindly come to my lord, 12.5, my lord.
Which page?
This is my lord, 64.1 2B, my lord. Next page, my lord. If the
64.
parties may waive off applicability of subsection 12.5 Arbitration and Constitution Amendment Act 2015 if they agree for such waiver is in writing after dispute having arisen between them in the format given under annexure 15 of this condition, my lord. On the next part, my lord, my another point is that, my lord, according to instruction, my lord, that, my lord, new amendment 2019, my lord, it is.
Let us come to 12.5 once.
Yes.
Let us come to 12.5, which you have waived.
12.5.1.
This is the Eastern Railways general conditions of contract for all railways.
Railway. This is Shialda, my lord, maintenance some development work. My lord.
Parties may waive off the applicability of subsection 12.5.
Yes, my lord, 12.5.
Be under an express agreement in writing by the parties. After the disputes have arisen.
Yes.
12.5.
That's a waiver, my lord, given under 12.5, if the parties so agree.
Notwithstanding any prior agreement to the contrary, it begins with that.
Yes, my lord.
This is a prior agreement, GCC.
Yes, my lord.
You say this is a part of the main agreement with them.
Yes.
Subsequent to the disputes having arisen.
Yes.
That is the proviso.
Yes.
12.5.
12.5.
Subsequent to dispute, there has to be something. If it's in the GCC, it has to be pre-dispute.
Yes.
GCC is on the contract stage.
Yes, my lord.
That has to be pre-dispute before dispute.
Pre-dispute, my lord.
Has to be
Has to.
by definition. Otherwise, it cannot be general conditions of contract.
Yes.
So this clause will go.
Yes, my lord.
In your section 11 application, I'll have to set aside this clause as bad.
That may be, my lord. Another point, my lord, 64.
That will be your first ground in the appeal only.
Yes. But one new amendment has, my lord, categorically changed the previous amendment, my lord, as far as 2019 is concerned.
This
So,
is the
my lord,
latest
your-
amendment.
2019 amendment. That
I have a copy, my lord. I shall, my lord, may I hand over, my lord, a copy of this?
Yes,
I am
sure,
also
right.
relying on that copy.
So you're relying 64.1. Your first point is that
the general manager, my 63.
general manager authority, yes.
Yes, ma'am.
But I mean,
Yes.
could not be addressed to general manager.
Yes, ma'am. Number second, my lord, 64.3A, my lord. Appointment of arbiter where application of section 12.5 Arbitration Constitution Act has been waived, my lord.
3A,
3A, my lord.
64.1 3A.
Yes, my lord. This is under, my lord, one, not exceed, my lord, 1 crore, my
No,
lord.
where is that?
56, next page, my lord.
But page 87 of my lord, the compilation that I've handed over.
Page 87 now. Sixty-three A only, bottom, my lord, 3A1.
No, sorry, it says 2B is not bad.
Yes,
It's in consonance with 12.5. Yes, very good, yes. If it is waived, where is the waiver?
but that railway
GCC
not,
says it can be waived.
yes, my lord.
GCC is in terms of your 12.5.
Yes, my lord.
So where is that waiver?
However, that is my next page, 63A, my lord. That is,
No. I mean, both of you had to sign it to waive
yes, my lord.
subsequent to the dispute
Yes,
as per your GCC clause as well as 12.5.
Yes, my
So
lord.
where is that? Signed by both parties?
That is not available.
And can I look into that in section 11 stage? You tell me that. If you say I'll open it wide, section 11, contrary to NN Global and Dolia or whatever.
But I have some relevant judgment regarding, my lord, this.
Relevant or not, I'll decide. But these are post NN Global and Dolia or before that?
Before that, my lord. But some clarification is there, my lord, that may be considered, my lord.
That's very well, definitely. You are entitled to argue. Yes. So what is the third point you said? 64.3 A.
Yes, my lord.
So that is the procedure if you waive.
Yes, my lord.
So that has naturally not been followed here.
Yes, my lord. You should kindly come to, my lord. This is, you should kindly see that 2004, my lord, 10 SCC 504.
Copy আছে? এগুলো তো সব প্রি অ্যামেন্ডমেন্ট।
হ্যাঁ?
এগুলো তো সব প্রি অ্যামেন্ডমেন্ট।
PM
2015 অ্যামেন্ডমেন্টের আগে।
যাই হোক, আমি দর্শক ফেরত দেখাই।
আচ্ছা।
2010?
2010, my lord, 2004, my lord, 10 SCC 504, my lord. Another, my lord,
Have you got copies of those?
yes, my lord, I had copy.
Give the copy.
Copy is not available, only books, my lord. 2006, my lord, 13 SCC, my lord. Another, may I read, my lord? That is
Which
important.
paragraph of 2004?
2004, my lord. Paragraph 4, 3 and 4.
4?
3 and 4. Paragraph 3 and 4.
3 and 4. What does it say? Because I don't have a copy of that judgment and you have not read it out. So I don't know what is there.
I can
Read it out.
Yes. Demand of arbitration. 2 arbiters shall be gazetted railway officer of equal status to be appointed in the matter laid in clause 64(3)(b) for all claims rupees 5 lakhs and above, and for all claims irrespective of the amount of value of such claims if the issue involved are of a complicated nature. The general manager shall be sole judge to decide whether the issue involved are of a complicated nature or not in the event of 2 arbitrators being undecided in their opinion. The matter under dispute will be referred to an umpire to be appointed in the manner laid down subclause 3B for his decision. Another subclause 3A to 3, Malar, in terms of this contract, that no person other than a gazetted railway
All this
officer.
happens if there is a waiver.
Yes, Malar. In view of the expression.
Why is it relevant? Why do you say it's relevant? In your case, where is the waiver?
Malar, relevant is that, Malar,
Once there is a waiver, there is a waiver by both of you, post dispute arising,
yes, Malar.
then this applies, 3A.
Yes, Malar.
You are reading something, some judgment on 3A, 64.3A.
Yes, Malar.
In your case, where is the waiver to invoke this this clause? And if not, then why is it relevant at all?
Because, Malar,
Because it's on 64.3A.
63A, Malar. Because
Whatever judgments are there regarding railways, cite those on various points. There are so many sections in the Railways Act.
yes, Malar.
There are various judgments on each of the sections.
another judgment that is 2006 2006 Supreme Court 13 SCC 240 page 240
240, yes. Which paragraph?
paragraph is paragraph 4 3 and 4
What did they say? You have a fascination on 3 and 4.
3 and 4
Yes. What did they say? Those paragraphs.
they say regarding
No, not your version. What is written there?
the learned additional solicitor general appearing on behalf of the appellant Union of India has pointed out that as per clause 63 and 64 of the general condition of contract, this court is no uncertain terms has held that the arbitral tribunal has to be constituted as per general condition of the contract. The High Court should not interfere under section 11 of the Act, and the High Court should accept the arbitral tribunal appointed by the General Manager, Railway. In this condition, the learned ASG invited our attention to a decision of this court directly bearing on the subject in Union India versus MP Gupta, wherein the similar question with regard to appointment of a arbitral tribunal for the railways with reference to clause 64 of the general condition of contract came up before this court, and this court held that where two gazetted railway officers are appointed as the arbitral tribunal in High Court should not appoint a retired judge of a High Court as a sole arbitrator, and appointment of sole arbitrator was set aside. Next was the condition of clause 63 and 64 of the general condition of contract are almost analogous to the one who we have in our hand. In that case, also relying on clause 64 of the contract, 3 judges bench presided over by the Chief Justice of India observed as follows. In view of the express.
Was this in the context of 64.1 Roman I? I mean, 1.1. Para 3 or 4?
64, 63 or 64,
Generally.
Generally.
What was the context?
That is
there?
the meaning that I procured this judgment.
May I, my lord, cut it a little short, my lord. My lord, section 12.5, my lord, subsection 5 came in on, my lord, 23rd of October 2015. All these judgments, my lord, are pre, my lord, the amendment of 12.5 and the schedules brought in, my lord, under.
That is not
Schedule 5
clarified
and-
all the judgment, next past judgment. That is my impression.
That is why, my lord, the judgments, the preceding judgments, starting from TRF to Perkins to after that, Honorable Justice Bhanumati's judgment in the railway matter, and thereafter Vidya Drolia and in local.
At first, their technical point, is that they are applied before the general manager, not AGM, other authority. So that can be set aside at first, that then judgment comes into consideration before your court, That is my first objection before your lordship.
Good. Yes, what is your answer on this technical objection?
Well, the technical objection,
Yeah,
if your
well.
lordship kindly sees, my lord, the contract, which is at page 18, your lordship will find, my lord, the person, my lord, issuing the contract is, my lord, the divisional engineer. In other words, my lord, the divisional railway manager to whom I have written, my lord. The contract, my lord, signing authority.
No, but clause 63.1 says that you have to all.
Yes, my lord, if your lordship kindly allows me to, my lord, go through clause 63.1A.
Yes.
My lord, of course, my lord, I fall within the, my lord, ambit of, my lord, 1 crore dispute because my claim is, my lord, 50 lakhs.
1 crore is accepted from here.
My lord, 1 crore comes under 64.3AI, my lord. 64.3AI, which is at, my lord, page 87 of the compilation which I have given, my lord. Or the GCC rather. 64, clause 64.3AI.
CI does not exceed the 1 crore. That
Yes.
is that is means below 1.
So my claim is, my lord, 50 lakhs and not. So, my lord, I come under, my lord, this 64.3AI, which is the relevant clause, my lord, which says, my lord, that the arbitrator, sole arbitrator will be appointed by the general manager or Malad be
Yes.
nominated by the general manager.
Yes.
Now, the question of Malad, the general manager either acting as the sole arbitrator or appointing any person as the sole arbitrator.
Sole authority.
Malad, I think Malad, both of us cannot submit.
Why both of you submit together? It's an interesting approach to adversarial litigation. Yes.
Malad, so Malad, the fact that Malad, the general manager is being Malad, is the Malad person who will either be acting as a sole arbitrator or appointed or nominating some person. Malad has been well discussed in Malad all these judgments of Malad Perkins or TRF or Malad thereafter Malad Honorable Justice Bhanumati's judgment. Malad, in all of them, Malad, the general manager is debarred from Malad acting as the sole arbitrator. So Malad, the person concerned is the Malad, the issuing authority. The issuing authority, Malad, I have written to them. And Malad, interestingly, Malad,
What about 63.1 that you have to refer the dispute to the general manager? The dispute, not the appointment of arbitrator. 63.1.
63.1.
After 63, 63.1, not
What
one
has
more.
happened, Malad? I'll tell you, Lordship, what has happened. Malad, initially, Malad, I give a demand notice. I give a demand notice and there is a pre-arbitration meeting going on. Pre-arbitration meeting, there was minutes drawn of the pre-arbitration meeting. After the pre-arbitration meeting, that is in my respectful submission, the conciliation meeting. Thereafter, they gave Malad 3 notices asking us, requesting us, you please waive section 12.5 for the waiver of section 12.5. So they admit that the arbitration clause is there. After Malad, the conciliation meetings were
You have
over.
annexed here.
Yes, of course, Malad. If your Lordship kindly takes Malad, Malad, the arbitration, Malad, pre-conciliation meeting, Malad, starts at Malad, page 33.
Arbitration clause probably your learned friend is not disputing.
No. And
Because he's
moreover,
saying it is there. And he says on twofold grounds. One, you have to refer the dispute to the general manager,
yes,
which you have not done. Secondly, is these judgments on 64. What is the modality to be applied, which has been settled by the Supreme Court before the amendment came.
Malad, that clause probably I will deal in later because that will be something which will be easier to deal with. Now, Malad, kindly consider the technical objection which has been raised by
Only
one
that.
defendant. Only
Yes.
that. So, Malad, if your Lordship kindly takes Malad 63.1, it says Malad, matters finally determined by the railway. My Lord, in my respectful submission, if your Lordship kindly considers
63.1 does not say that.
matters finally determined by the railway.
Or determined by the railways. All disputes are to be
all
referred to-
disputes, yes.
Yes.
Now, Malad, if your Lordship kindly considers Malad, page 33 of my application, Malad. Malad, the pre-conciliation or the conciliation or the pre-arbitration meeting was not under Malad 63.1. If your Lordship sees, Malad, nowhere it is referred, Malad, 63.1. They have not invoked 63.1. Now, if your Lordship kindly takes, Malad, the last minutes, which is drawn at page 47, is on 24th of June 2022.
What is the exact dispute?
Malad, dispute is with regard to Malad, the work was Malad, improvement of the railway platform, the Shialda division.
Yes.
And Malad, with regard to that, Malad, my claim is on account of damages. My claim is on account of damages for Malad. I have done Malad half of the work done, not paid really Malad. Some Malad work done, not paid, and rest of them Malad on account of Malad damages. Materials procured thereafter Malad could not work hindrances. So Malad, page 47, your Lordship will see Malad the date of the meeting. This is Malad termed as pre-arbitration meeting. Nowhere Malad, if your Lordship kindly sees Malad this document, nowhere have they mentioned Malad clause 63.1. Now, if your Lordship kindly takes Malad page 52 onwards. Page 52, your Lordship will find Malad 1st August 2022. This is after Malad the pre-arbitration meeting. They ask us, Malad, kindly waive Malad section 12.5. And please give a reply. 3 consecutive letters after the pre-arbitration.
Probably 63.1 does not apply to
Absolutely, but I'm
the
grateful.
invocation under section 21. It's the first reference of the dispute. Now, in your case, there was a dispute which is admitted from the pre-arbitration proceeding.
Pre-arbitration proceeding.
So that this is prior to the dispute, the first reference of the dispute has to be made to the general manager. Now, your learned friend is probably attacking the section 21 invocation that could not be made to the general manager. There is no such bar here.
Yes, there is.
Apparently.
Yes, yes. And moreover, absolutely, I bow down to your lordship, my lord. Only one last aspect is, my lord, with regard
21
to
is the reference to the arbitrator, to arbitration,
yes.
not reference to of the dispute.
No, 21 is, my lord, commencement of the dispute. It says, my lord, commencement of
That
the
dispute is on a different note. The dispute between, let us come to 21 once.
Yes, sir.
21 is not commencement of dispute, cannot be.
No, not commencement of dispute.
You said
Commencement
that.
of the, I'm sorry. my lord.
So commencement of arbitral proceedings.
Arbitral
It's
proceedings.
entirely on arbitral proceedings.
Absolutely.
Unless otherwise agreed in respect of particular, yes. Here, the arbitral proceedings in respect of a particular dispute commence.
Commence.
The arbitral proceedings commence in respect of a particular dispute.
Yes.
Dispute commences previously.
Previously, yes.
Has to,
yes,
otherwise
has
how
to.
can there be a
Otherwise,
reference?
how can there be 21?
So this is entirely on reference to
Yes.
arbitration.
So,
On
which
which
is
a request for the dispute has arisen. Section 21 is on which a request for that dispute to be referred to arbitration is received by the respondent.
section 21 is really, my lord,
21
the
is not the
commencement of the
dispute.
arbitral proceedings.
Absolutely has to be.
Has to be, my lord. And, my lord, this, my lord, 63.1, my lord, the conciliation pre-arbitration, my lord, they have termed it pre-arbitration, but my lord, really it's conciliation, my lord, meetings. Conciliation meetings, my lord, have taken place after the disputes were, my lord, raised, and thereafter, my lord, this after the pre-conciliation meetings were over, they have, my lord, given us, my lord, section 12.5 waiver notices, saying that please waive off section 12.5. That, my lord, tantamounts, my lord, admission of the arbitration clause, admission that there is a dispute between the parties, and the fact that they want to go for arbitration, just that they want to, my lord, appoint, my lord, retired railway officers, which is, my lord, barred now, my lord, under section 12.5, read with the schedules 5 and 7.
What is the dispute quantum?
My lord, 50 lakhs, my lord, page
Tell me,
26, page
Tell me
26,
the quantum.
my lord, 50 lakhs, 81,224. my lord. This is, my lord, at page 32. If 26 is the notice, 32 is more.
The present section 11 application has been filed by a contractor of the Eastern Railway on an alleged dispute pertaining to the claim of the petitioner for damages and certain alleged unpaid amounts for the work done by the petitioner. Whose sub next para, learned counsel for the petitioner places reliance on an arbitration clause. What is the page number of that?
My lord, this is, my lord, page 18 is the contract which refers to the GCC, and my lord, GCC at page 87, my lord, is 64 3A Roman 1, which is not part of the petition. My lord, GCC I have, my lord, referred to, my lord, separately.
Which is
Page
contained in the general conditions of contract of the Indian Railways comma, which pertains to appointment of arbitrator. First up, it is submitted that the present dispute falls within the purview of such arbitration clause and comma as such comma is required to be referred to arbitrator. First up, however, comma, since there was no agreement between the parties regarding the arbitrator to be appointed, comma, the present application has been filed. First up, next para, learned counsel appearing for the respondents objects to the reference to arbitration under section 11 primarily on two grounds. First of, the first ground on which such reference is opposed is admittedly of a technical nature. First up, it is argued that clause 63.1 of the general conditions of contract within bracket caps a GCC bracket closed clearly stipulates
2019 man.
Acha, very well. Comma 2019. This is it. Pore comma 2019 comma clearly stipulates that all disputes and differences of any kind whatsoever arising out of or in connection with the contract, comma, whether during the progress of the work or after its completion, comma, shall be referred by the contractor to the within double inverted GM double inverted close within bracket caps a general manager bracket closed. First of next para, In the present case, comma, however, comma, the invocation was not sent to the general manager, comma, it is argued, comma, the notice of demand itself for pre-arbitration was referred to the divisional railway manager, as evident from Annexure B at page 26 of the present application. Hence, comma, such dispute cannot be termed as a dispute within the contemplation of Section 21 of the Arbitration and Conciliation Act 1996. Secondly, comma, learned counsel submits that clause 64 point within bracket 1 bracket closed Roman II our bracket II again bracket small b provides that the parties may waive 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 off OFF the applicability of subsection 12 within bracket 5 of the Arbitration and Conciliation within bracket Amendment bracket close Act 2015, comma, if they agree for such waiver in writing, comma, after dispute having arisen between them in the format given therein. Full stop. Next para, it is argued that section 64.3 within bracket 3 our within bracket small a of the GCC further provides the modality for appointment of arbitrator where applicability of section 12 within bracket 5 has been waived off. Full stop. Next para, learned counsel for the respondent seeks to place reliance on two judgments of the Supreme Court, comma, respectively reported at 2000 SCC 504 and 2006 13 SCC 240. Full stop. Next para. It is contended that the said judgments clearly referred to the clauses cited by the respondent and clinch the issue against the petitioner as regards the provisions of the GCC that the arbitrator, comma, if appointed, comma, has to be the arbitrator as envisaged within the GCC. Full stop. Next para, hence, comma, the present reference sought under section 11 is not maintainable, comma, it is argued. Full stop. Next para, learned counsel appearing for the petitioner controverts such contentions and submits that there were pre-arbitration within single inverted pre-arbitration single inverted close proceedings between the parties, comma, which is in effect a conciliation proceeding, comma, where it was an admitted position that disputes had arisen between the parties. Full stop. Next para, hence, comma, it cannot be said that the reference to dispute itself was bad. Full stop. Next para, it is further argued that both the judgments cited by the respondent were passed prior to the amendment of 2015 and, comma, as such, comma, are not germane for adjudicating the present LIS. Full stop. Next para, it is further argued that section 64 point within bracket 1 within bracket II within bracket small b clearly envisages that the parties italics may শুধু italics মেয়েটা শুধু italics waive off the applicability of subsection 12 within bracket 5, comma, if they agree for such waiver in writing, তারপর আবার italics after dispute having arisen between them, এটা italics. Full stop. Next para, in the present case, comma, however, comma, there was no such agreed waiver in writing, comma, for which the subsequent clauses do not apply in the present case. Full stop. Next para, a perusal of the clauses, relevant clauses of the GCC along with the memorandum of agreement dated March 10, 2015 executed between the parties clearly indicates that the dispute arising between the parties falls within the domain of the arbitration clause. Full stop. Next para. However, comma, neither of the objections raised by the respondent can be entertained for the reasons as noted below. Full stop. Next para. Inasmuch as clause 63.1 of the GCC is concerned, comma, the same merely refers to the reference of the dispute itself, comma, at the inception, comma, by the contractor to the general manager of the railway. Full stop. Next para. However, comma, the said clause does not have any material bearing on the language of section 21 of the 1996 Act, comma, which is not merely a reference of the dispute, but a reference to arbitration of the dispute. Full stop. Section 21 contemplates that, comma, unless otherwise agreed by the parties, comma, the arbitral proceedings in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. Full stop. Next para. Hence, comma, section 20, an invocation under section 21 cannot be circumscribed by the relevant clause, that is clause 63.1 of the GCC, comma, which is cited by the respondent. Full stop. That apart, comma, since pre-arbitration stroke conciliation proceedings have already been going on between the parties, comma, the dispute having arisen between the parties or the veracity of such raising of dispute stands itself undisputed. Full stop. Next para. Insofar as the judgments cited by the respondent are concerned, comma, on such score as well, comma, learned counsel for the petitioner is absolutely justified in submitting that both the said judgments are of the ERA prior to the 2015 amendment to the 1996 Act. Full stop. That apart, comma, the petitioner is also justified in contending that clause 64.1 within bracket II within bracket small b clearly contemplates that if there is an agreement for waiver in writing after the dispute having arisen between the parties, comma, the said clause is applicable. Full stop. Next para. However, comma, in the present case, comma, there is nothing to indicate that there was ever any such waiver in writing after the dispute having arisen. Full stop. Next para. In such view of the matter, comma, it cannot be said that the reference sought by the petitioner is not maintainable in law in any manner whatsoever. Full stop. Accordingly, AP 27 of 2027 is allowed, comma, thereby appointing advocate of this court or
Not 50 lakh rupees claim.
What is better, my lord? Very
Very
small amount, my lord.
Number going to
Okay.
Naam to blank. I'll appoint, sir. Yes, you have any agreed name?
Petitioner have, my lord, some
I
like.
have some name that I've shown it to my learned friend Manoj also. Because your lordship would have indicated, because last occasion I could not give any names. So Manoj.
They are all bar library member.
No, one of them Manoj is not
I don't know, my lord. The junior member, my lord.
junior.
No, let me appoint somebody else.
Yes. I'll leave it to your lordship.
Achha, what is the seniority of Noel Banerjee? Not
Yeah.
very senior.
No.
You don't even know her probably.
No, of course I know. Of course I know. Manoj.
Anybody can use.
No, a bit more senior probably.
Who can handle this matter? That is also one of- because arbitration matter, my lord, is quite defined.
Very well. Appointing Mr. Shakko Sen, comma, an advocate of this court and a member of the Bar Library Club
Better,
against
my
your
lord.
apprehension, as the sole arbitrator to resolve the dispute between the parties, subject to obtaining declarations to consent under section 12 of the Arbitration and Conciliation Act 1990.
I'm so grateful.
Thank you.
deeply obliged.
আচ্ছা ওটা কি বলেছি? কোনটা দুদিন ধরে ফেল করে জানি ভুলে গেছি। ওটা ওটা একটা লাইন ফেল দিকে। এটা কি রিপ্লাইয়ের কপিটা? ঠিক আছে, ওটা তো ওপেন কোডই সাবমিশন করেছে। সাবমিশনটা তো ওপেন কোডেই হয়েছে। সাবমিশনটা তো ওপেন কোডে হয়েছে, আমি সাবমিট করবো কেন? কালকে টু বি মেনশনে থাক, ওটা অ্যাড করে দেবে। হ্যাঁ, বিহাইন্ড দ্য ব্যাক কোনো অর্ডার করবো না, কালকে টু বি মেনশনে থাক, ওটা অ্যাড করে একটু মনে করে দেবেন, জাস্ট কালকে টু বি মেনশনে।
My lord, just one indulgence, my lord. Item 2 to 4, my lord, got passed over. Will it be your lordship's pleasure to take it? My lord,
If I
Mr.
can,
Banerjee
yes.
is there
I
on
am
the side.
conceding to the prayer, my lord. I am conceding.
Oh, definitely.
Prayer of being taken up.
No, which item was taken up last?
9.
Item 9. তুই
Nine.
অন্যদিন চাইছিস।
The,
সেটা বলে অন্যদিন করে নে তাহলে।
no, let me call up till 12 at least.
Well, only thing is that I believe what my learned friend is not able to say is that I am conceding, but since his senior is not there, Mr. Dhruv Ghosh, he'll miss his fees. So he wants it on some other day.
Lord,
Dhruv is not in court.
yes, my lord, he's not in court. My lord, kindly keep it on 2nd.
I would have conceded to that also. So Malad keeps it on
2nd of
some
May or 3rd of May, my lord. Any
I
day.
don't object, Malad.
2 to 4.
Yes, my lord, 2 to 4. And DCS was a
If
straight.
somebody will remind me, I'll definitely, whichever date suits both of you.
Yes, my lord. After item 12.
If it is called on second call,
Very much.
if it is called on only,
I shall indicate, my lord.
I have no Malad objection.
I'll be there, my lord. I shall indicate.
no, I'll remember that. 2 to 4, I'll remember you have no objection. Keep somebody or be there.
Yes, my lord. I'll be
Great,
there. I'll
great.
be there. I'm much.
With my lord's kind indulgence, my lord, item number 10 and 11, the next two matters, my lord, humbly praying if my learned friend is there, if it can be taken up day after tomorrow. I've received the reply yesterday, a bit late.
Item number 10 and 11.
You're for the DVC?
No, my lord.
I'm appearing
lord is just-
I'm appearing for the DVC, my lord.
Oh,
Led by Mr. Bandyopadhyay, my lord.
My lord, can you take it up day after tomorrow? If my
you're
lord.
for the whom?
My lord, I'm for the
My lord,
respondent. my lord.
Mr. Bandyopadhyay.
Yes, Mr. Bandhavata, till time is being.
Day after tomorrow, if my
He has already told me now.
On the prayer of learned counsel for the respondent, the matter shall, the matter is adjourned till,
Whether the reply may be kept with the record.
is adjourned till day after tomorrow means which day? 28th?
Yes, my lord.
Friday?
My lord, Friday, 20th.
Adjourned till April 28, 2023.
Deeply
Full stop.
obliged,
The, you have filed your opposition.
My lord.
The reply filed today be kept on record. 10 and 11.
My lord. Deeply obliged.
There are two replies.
Two replies. My lord, there are two applications under section 11.
Replies.
Two replies, my lord.
10, 11 একসঙ্গে there will be a common order. Replies in both. আচ্ছা, আমি একটু 5 মিনিট বাদে যাচ্ছি, ডেকে নেব 12 থেকে। হ্যাঁ,
Grateful, my lord.
yes.
Grateful, my lord.
Item number 12. Vinit Gupta versus Mrs. Giggles Private Limited.
Your lordship, I'm being led by Mr. Mantha in this matter. I'm for the respondent. Your lordship, Mr. Mantha is not
Lord, I'm for
feeling
the
well.
petitioner,
He
ma'am.
hasn't come to
Not
court.
feeling well.
Yes, your lordship. He hasn't come to court.
I'm for the petitioner, my lord, led by Mr. Dheeraj Trivedi.
Mr. Mantham is Justice Mantha's son.
Yes, your lordship.
So yes, that does not make a difference.
Your lordship, not this week.
Does
your
not at
lordship.
all make a difference. But she's praying time on his illness ground.
My lord, no problem.
Whatever you say,
Kindly
Not-
fix any day next week.
next week,
Yes, your lordship. Next week is.
on the prayer of the petitioner, the matter is adjourned till,
My lord, respondent, my.
oh, you're for the respondent. On the prayer of the respondent, the matter is adjourned till May 2, 2023. 2nd May.
I'm grateful.
Grateful, your lordship.
কোর্ট অ্যাপ্লিকেশন ডেকে দিন, পাস ওভার গুলো এখন ডেকে দিন, তাহলে পাস ওভার গুলো ডেকেই দিন, তারপর 13
Item number 2 to 4.
পাস ওভার ম্যাটার্স, yes.
Passover matters.
Yes, my lord.
2 to 4 that matters. You are there for the
I'm the respondent. I'm for the petitioner, my lord.
on the prayer of the petitioner, 2 to 4. On the prayer of the petitioner in all the matters, comma, the matters are adjourned till
2nd of May, my lord.
May 2, 2023.
I'm much obliged. Grateful.
পাসওয়ার্ড হোক দেখেন দেখে নিন হ্যাঁ দাঁড়াও পাসওয়ার্ড গুলো ডাকুন
হ্যাঁ,
আপনি,
ঠিক আছে,
আপনাকে কি ডাকতে বলেছে
Item number 6,
ইয়েস
passover matter.
But I am opposing to that.
My petition,
হোয়াট ইজ দ্য ম্যাটার
my lord, 11-6, my lord, appointment.
আচ্ছা ইউ আর ফর দ্য রেসপন্ডেন্ট
I am for the respondent number 2, 3, and 4, not for the one, because the one farm has been dissolved. He has been wrongly implicated as a party.
হোয়াট ইজ ইউর স্ট্যান্ড অন দিস ইউ আর অবজেক্টিং
My lord, I have serious objection on the point that the section 21 notice, my lord, which has been issued, my lord, that itself exemplifies that the claims are hopelessly time-barred. Second point is that, my lord, that apart section 21 notice is also, my lord, very much vague, which does not disclose any existing dispute at all. Because the object of section 21, my lord, is well established by several case laws, my lord. It gives an opportunity to the parties to know what is the claim about. You don't have to mention the particular amount, but what he is exactly doing, my lord. If your lordship kindly comes to, my lord, section 21 notice once, my lord.
So these are the two objections.
Time barred, section 21, and my lord, misjoinder of party. And the farm has been dissolved, my lord. The farm has
Achha,
been made
that
a part.
also. Very.
And I would be liking to file an affidavit also if your lordship so directs, you know, if so directs, you know. If
So
your
let us see if it is necessary. I'll
Yes.
Yes. What do you say?
My lord, my lord,
You get the contours of the objections, so you
Yes.
can deal with that. Mr. Ghosh, one is time barred. Second is there is no existing dispute. No claim has been specified in your section 21. Thirdly, misjoinder because the partnership firm has been dissolved in the week. But prior to this,
My lord will, in regard to the fact that whether any dispute has been stated or not in the section 21 notice.
let's come to the section 21 notice first.
My lord.
Because your learned friend's argument is that from the section 21 itself, time bar will be specific.
My lord will kindly come to page 69, my lord.
You please take your seats. I'll call upon if necessary. Yes. Yes. Yes, Mr. Ghosh.
But, so from the second paragraph, that by passage of time, though the volume of business increased rapidly, but however, I have never been allowed to sign as a partner of the partnership firm or to participate in the day-to-day business activities of the firm. And before taking any decision, with regard to the business of the partnership firm, no consent or approval was ever been taken from the undersigned. Although I'm a partner of the partnership firm, I was also never been paid the actual ratio of profit accumulated from the business of the partnership firm as per the ratio contemplated in the partnership deed. Rather, the undersigned has always been compelled to sign all the papers and documents as per the dictation of the purported managing partner, and although the undersigned did not receive the actual entitlement as per the provisions of the partnership deed.
No, you have not specified any claim. What is the claim?
My lord,
What is the dispute?
but that is the dispute, my lord. I have not been permitted to participate in the business, not signed.
You have to clearly state what is the claim, what is the dispute. You have not claimed any amount, no cause of action even. If this was a plaint, it would be rejected on the face of it.
My lord knows that I have to file a statement of claim giving the complete particulars. But
Statement of claim is different, but they have to know the contours of the claim, of the
The
dispute at least. This is not a dispute. Undersigned has always been compelled to sign all the papers and documents as per the dictation of the purporting. So what? Suppose you are compelled. Even then what?
But
That may be your grievance,
my lord,
but that is emotional.
but my lord,
Practically, what is your claim?
but practically that is a breach of the terms and conditions of
You
the.
have not even averred here or even mentioned here that there was any actual claim of yours. You say undersigned did not receive the actual entitlement as per provisions of the partnership deed. What is the actual entitlement according to you? Nothing has been specified here.
My lord, maybe the invocation notice specifically does not say so, my
It
lord.
does not say anything at all. It says, yes, that you are never paid the actual ratio of
Minor.
profit. It's very vague, Mr.
But
Ghosh.
the
Right or-
the amount may not have been mentioned, but the dispute has been mentioned, subject to my lord's correction, my lord. The amount may not have been mentioned, my lord. The specific amount has not been mentioned. I cannot run away from that, but the dispute has been mentioned.
What about the other point? Other 2 points actually.
My lord.
Time barred, they say.
Time barred, my lord, that is a matter of trial, whether the entire claim is time barred or part of the claim is time barred. I have not specifically made a claim that has to be adjudicated by way of a trial, my lord. This cannot be adjudicated probably in an application under section 11, my lord.
What was the technical error previously?
A technical error previously, what had happened, my lord, the person who had sent the letter did not even sign it. That was a technical error for which section 11 was.
And she has issued a spate of letters to other authorities saying that my signature may be forged. So don't accept any letter.
Even today forgery can be decided by an arbitrator, my lord.
Of course, I don't want to reject this right now. File your affidavit. How soon can you do it? Do it soon.
2 weeks, my lord.
2 weeks. 3 primary objections have been raised by the respondents to the present.
Respondent number 2, 3, and 4.
Achha. By the respondent numbers 2, 3, and 4 against the reference sought under section 11 of the Arbitration and Conciliation Act 1996. First comma, it is argued that the claim sought to be made by the petitioner is palpably time barred, comma, as is clear from the purported invocation under section 21 of the 1996 Act itself. The second question argued by the respondent numbers 2 to 4.
May I have your lordship's kindly?
Yes, is that no specific dispute has been referred to in the purported invocation notice worth being referred to arbitration. In fact, comma, there is no existing dispute as such or any specific claim, comma, since nothing in that regard has been even indicated in the invocation under section 21. Next para. Thirdly, comma, it is contended that the respondent number 1 firm was dissolved prior to filing of the present application and, comma, as such, comma, the present application is bad for misjoinder of unnecessary parties. Next para. Learned counsel appearing for the respondent further indicates that the alleged author of the invocation under section 21 has been issuing a spate of letters to various authorities, comma, disputing her own signature in the said letter. Next para, be that as it may, comma, since the respondent numbers 2 to 4 seek opportunity to use an affidavit in opposition to bring on record the aforesaid allegations, comma, the respondents are directed to file their affidavit within bracket S in opposition within a fortnight from date. Reply, if any, shall be filed within a week thereafter. The matter shall be listed for hearing on May 16, 2023. 16th May. Very full.
On 16th, my lord, I have some difficulty. Maybe on 17th or 18th, my lord.
Yes. What do you say? 17th.
17th.
15th?
Deeply obliged.
17th. Written. Call on the expert.
Deeply obliged.
Yes. করে দিন, কারণ অরিজিনাল সেটটা শেষ করে দেখি হয়তো হয়ে যাবে। সব হয়ে গেল তো? পাস ওভার ম্যাটার? হ্যাঁ, পাস ওভার কিছু নেই তো? কল করুন।
Item number 13.
No, item number 13, I beg to appear on behalf of the CAC.
Yes.
There was a direction by your lordship to file a report, my lord. I've given it to him just 10 minutes back. May I file the?
Come back tomorrow. Come back tomorrow.
May I file the report?
Come back tomorrow. Give a copy to Mr. Haldar also.
I give it.
File it, the report. As per previous direction of court, comma, a report is filed by the CSC Limited, which be kept on record. Full stop. Since a copy of the same has been circulated here and now, comma, to enable learned counsel for the parties to get prepared on such report, comma, the matter is adjourned for the day and shall next be listed tomorrow under the same heading.
I have therefore stated this matter. Can I have a copy of the report which has been?
Yes, yes. Please give a copy of the report to the state also.
Contempt matter, item number 14.
This is my contempt petition. There was a direction for affidavit on 17th of January. Your Lordship, that has not been filed subject to, because nothing has been served upon us. This is Your Lordship from contempt from Your Lordship's order for 21st June 2022, where Your Lordship directed the respondent to disburse a sum under the incentive scheme, some more than 1.94 crores. That has not been paid. They have preferred an appeal. The appeal is there. There is no stay. But Your Lordship, if Your Lordship sees the last order, this was adjourned, Your Lordship, because the appeal was pending. Now they have not taken any steps to move the appeal. When they have moved the appeal earlier, but thereafter they have not taken any steps to list the appeal and thereafter move the appeal any further. So as on date, there is no stay. I leave it to Your Lordship.
So they cannot keep it indefinitely there. I'll record some orders so that it helps you. None appears for the alleged contemners at the time of call, comma, although the petitioners are represented through counsel. The contemner actually, I'm sorry. Petitioners are represented through counsel. Full stop. Next para. Learned counsel for the petitioners, comma, in his usual fairness, points out that an appeal at the behest of the alleged contemner against the parent order is now pending. Full stop. However, comma, it is also submitted that no substantive steps are being taken by the appellant stroke alleged contemner for early hearing of the said appeal, and no interim order has been passed in connection with the said appeal as yet. Full stop. Next para. Although mere pendency of an appeal does not operate automatically as stay of the impugned order, comma, for the sake of propriety, comma, since the parent order itself has been challenged in appeal by the alleged contemner, comma, another opportunity is being given to the alleged contemner to obtain necessary orders from the appellate court. Full stop. Next para. The contempt application shall be listed next on May 15, 2023. Full stop. It is, comma, however, comma, made clear that in the event the alleged contemner is unrepresented on the next date of hearing, comma, ex parte orders may be passed in the contempt application even in the absence of the alleged contemner. Full stop. The learned advocate on record for the petitioners is requested to communicate the next returnable date to his counterpart appearing for the alleged contemner by tomorrow.
Great.
আচ্ছা, অরিজিনাল সেট শেষ হয়ে গেল। অ্যাপিলেট সাইডের আগে আমি ঘুরে আসছি। এটা কি সই? এটা 5 না আজকে? আমাকে একটু বলে দিতে হবে আপনারা করেননি। আমার যেরকম অর্ডার ছিলেন তো ওরা ওনারা সেরকমই হবে 100 বার। কার হয়ে অ্যাপিল করছে লিখে দিয়ে যাচ্ছে না, স্লিপই দিচ্ছে না। ওহো, সেটা তো রিস্কি। যে দিচ্ছে না তাকে জনে জনে বলে। হ্যাঁ হ্যাঁ, I'll pick up the appellate set matters after 10 minutes.
For judgment, item number 1.
Hence, WPA 16229 of 2004 is allowed, thereby directing the WPA-CDCL to refund the amount of rupees 20 lakh paid by the petitioner as preliminary penalty to the petitioners by October 31, 2023, along with interest on the said sum of rupees 20 lakh at the rate of 6% per annum till the date of such payment. In the event such payment of rupees 20 lakh along with interest is not made within October 31st, 2023, the WBACDCL shall pay further interest for the period thereafter at the rate of 6% per annum on the entire quantum payable as on October 31, 2023, including the principal dues plus the interest accrued till October 31, till the date of final disbursement of the amount. There are no orders to cause certain certificate.
We, in terms of your interim order, we have paid also 25 lakhs on
Pardon?
last year.
You have paid?
Another 25 lakhs. In
25
terms of your-
lakhs?
In terms of your lordship's interim order. Passed in October 2022.
When the above judgment is passed, it is pointed out by learned counsel for the petitioner that pursuant to interim order of this court, the petitioner had deposited how much?
25 lakhs, another 25.
An additional amount of rupees 25 lakh to the WBS to the CSC Limited, to the WBACDCL. Full stop. Next para. Such amount, without any interest, shall be returned by the WBACDCL to the petitioners by May 15, 2023.
But actually, the 20 lakhs was received by Durgapur Project Limited, not WBACDCL.
You return
25 lakhs is
you have inherited.
Yes, that's inherited.
That's why 25 lakh within 15th. But the other amount I've given you sufficient time to go up to the Supreme Court even. This is a substantial amount. Definitely have a right to pay for an appeal. Yes,
For judgment, item number 2.
Accordingly, WPA 26937 of 2022 is allowed, directing the CSC Limited to hold an inspection at the premises in question within a fortnight from date to ascertain the feasibility of giving electricity connection to the petitioner, and upon such inspection, if otherwise feasible to give connection, to raise a quotation and serve it on the petitioner. Upon compliance of all formalities by the petitioner in that regard, the CSC Limited shall give the new electricity connection to the petitioner at the disputed premises within 1 week from the date of such compliance of formalities, either on the occasion of the inspection or giving electricity connection to the petitioner, if the CSC personnel are obstructed in any manner by the private respondent number 3 and or her men and agents in doing so, it will be open to the CSC personnel to approach the local police station for adequate police assistance, which will be given by the inspector in charge, stroke officer in charge as applicable of the said police station at the cost of the petitioner by acting on a server copy of this order. It will be open to the police personnel to remove any hindrance or padlock if put up to resist the CSC personnel from entering into the premises for the limited purposes indicated above. It is, however, made clear that nothing in this order and not the electricity connection, if given to the petitioner, shall prejudice the rights and contentions of the parties in any manner before any court of law or other legal forum, nor as to cause urgency. আগেরটা কিন্তু এই ওই পরের হ্যাঁ এই পোর্শনটা শুধু বলে দিতে হবে ওকে থ্যাংক ইউ
For judgment, item 3.
Accordingly, WPA 2051 of 2023 is dismissed on contest, but without any order as to cause urgent certified copies.
Lord, may I go through the judgment once?
It will be on the server very soon.
Grateful.
The difficulty is because we send these hard copies for them to be uploaded. That will be delayed in the.
Wait.
Motion, item 4.
Yes.
Mine Raman appearing in this matter.
Yes.
I'm paying for short Passover. Fine.
An adjournment is sought by the petitioners. Let the matter stand adjourned for the day.
Item 5.
Lord, I'm for the WBSCDCL.
None appears for the petitioner. Although the WBSCDCL is represented through counsel, let the matter stand adjourned and shall next be listed in the monthly list of May 2023.
Grateful, man.
Item 6.
I'm for the WBS.
Yes, Mr. Bhattacharya.
Well, I am for the petitioner. In last occasion, my lord was directed, my lord, to conduct an inquiry with regard to, my lord, the shifting of the, my lord, the overhead line, my lord. My lord, I have received a copy of the inspection report just now, my lord. May I go through and
Come back tomorrow with instruction.
may I come back on Monday?
My instead of Monday, can it be on Wednesday?
The inspection report as directed previously is filed by learned counsel for the WBSCDCL and be kept on record. Full stop. Since a copy of the same has just now been served on learned advocate for the petitioner, comma, on the prayer of the petitioners, the matter is adjourned and shall next be listed on May 3, 2023, Wednesday.
Deeply obliged. আমারটা দিয়ে দেন না নামটা।
Item 7.
My lord, I am for the petition.
I am for the
my
state
lord.
matter.
My lord, learned advocate Bapin Boito, my lord, did not come to the court, my lord.
Adjourned for the day.
Yes, my lord.
On the prayer of the petitioner, the matter is adjourned for the day.
Item 8.
Lord, I beg to appear on behalf of the state.
State. Since only the state is represented through counsel, and none appears for the petitioner or the other respondent, let the matter stand adjourned and shall next be listed in the monthly list of May.
My lord, just.
Call on the respect.
My lord, just Mrs. Sushmita Chatterjee is appearing in this matter, my lord.
Yes.
Item 9.
I beg to appear on behalf of the petitioner.
May 9 minute.
Licensing company, but if I have been given an incomplete copy of the petition, I'm told Mr. Mukherjee has a complete
But
copy.
yesterday, my lord, my learned friend has requested me. I have already handed over another fresh copy.
Lordship, I shall look at,
Right.
but in the
Lord-
meantime, Lordship, I am told by my learned junior that we went for inspection at the site. We were opposed by the private respondents. We would like to.
I am applying for the private respondent. I have to make submission, but before that, my letter friend is submitted. The private respondent objected. My lord, I shall come to my lord, I will submit what happened when they went to, and that was the earlier matter where my lords have been pleased to direct my client to make a representation. Liberty was given, read petition dismissed in the earlier petition. But how this petition has come before your lordship, suppressing a lot of material facts, which I want to bring to your my lord's notice. Let the petitioner submit.
Lordship, I'm told that the earlier matter is regarding pilferage.
But I have annexed that copy.
There is also a preference. My lord, kindly see the my last order passed by your lordship in the previous rate petition, which was filed by my client.
In this matter, there was a direction for holding inspection.
No, my lord.
No,
Fresh
no.
matter, my lord. Yesterday, your lordship took up the matter.
Then let us hear the matter.
Yes.
Yes.
My lord, kindly takes up, my lord, my petition, my lord.
Please take your seats, all of you. Yes, I'll just hear.
My lord, I do have two separate, my lord, business premises. One is 63 and 63/1 GT Road. My lord would get, my lord, at paragraph 4 of my writ petition, where I do have a separate electric supply. The another unit subject matter, my lord, that is 10 Durgadash Kuti Lane. kindly takes up, my lord, the deed, my lord, I have annex. Kindly takes up, my lord, page 12. My lord would get, my lord, page 13. The name of the owner is, my lord, Lokhi Narayan Jaiswal, the private respondent before your lordship, and the petitioners are, my lord, the purchaser. My lord, the schedule, your lordship, kindly takes up page 21 once of the registered deed. Lord, it's one self-contained flat, Lord, entire second floor, measuring an area of about 625 square feet. Lord, this is, Lord, by purchase deed, by virtue of which, Lord, I got, Lord, the business place at 10. Lord, this is, Lord, at 10, Lord, Durgadash Kuti Lane. Lord, schedule B, your lordship will get that at page 21.
Yes.
So here, Lord, I do have a separate electric connection, Lord, in respect of the another business place, Lord, I have disclosed that.
Self-contained flat is not there. One flat on the entire second floor containing
Yes, my lord. One flat.
That's
on
why
the-
self-contained.
Yes, yes. Entirety, my lord, of the second floor, containing an area of, my lord, 625 square feet, 10 Durgan. And, my lord, where, my lord, I have an existing supply that is 63 and 63 by 1. Here, my lord, I applied for, my lord, supply of, my lord, electric meter, commercial meter. My lord, kindly takes up page 26. Inspection was, my lord, informed that that will be carried out, my lord, on 9th of March 2023 between 9 AM to 1 PM. So it's quite illegible. My lord, kindly turns over the page 27. Here your lordship will get, my lord, a further communication from the CSC authority, where from, my lord, I came to know on behalf of the, my lord, private respondent, since objection is being made, my lord, I was required to forward a letter, my lord, intimating my stand. Kindly takes up, my lord, page 29 and page 30. I have informed that he do not have any locus standi. My lord, my stand is being, my lord, confirmed by a docket number being issued, my lord, on 20th March 2023. Now, my lord, what happened? Page 31, my learned senior friend wants to argue, my lord, on behalf of the private respondent. The private respondent alleging pilferage from his electricity meter is being done by me. My lord, filed one writ petition. My lord, kindly takes up page 31 and 32. Because he has a standing electric meter at 10 Durgadash Kuti Lane. There is no doubt on that. I do have a separate electric meter at, my lord, the 63 and 63 by 1 GT Road. He alleged that
He's an owner of that also.
No, what he has alleged in his writ petition, that from taking pilferage of electricity from his meter, I am running the business place at 63 and 63 by 1. So that is the allegation of pilferage. I shown before your lordship at the time that I do have a separate electricity connection at 63 and 63 by 1. So there is no necessity for, my lord, pilferage of electricity from his meter standing at 10 Durgadash Kuti Lane. Now, my lord, your lordship has decided the writ petition directing the CSC authority, since CSC authority at that point, juncture of time said that when the CSC authority went there to, my lord, inspect his electric meter, he himself raised objection. On that basis, your lordship disposed of the writ petition, giving liberty to the CSC authority to see whether any pilferage of electricity is there or not in his meter. Now, my lord, I applied for new electric meter at 10 Durgadash Kuti Lane.
What happened to that inquiry of the CSC?
But I do not know, my lord. No,
come to the CSC for that.
Yes.
That is it.
That is my.
What is your objection? Then I'll come to the CSC.
Lordship, kindly come to the page 3. I will show my 2 paragraphs only.
Page 3 of what? The order or the?
No, my lord, the petition.
Page 3, yes.
Paragraph 3.
3.
Your petition stated that after purchase of said flat, 2019, the flat was purchased. And that time it was a godown. Your petitioners are occupying and carrying on their business over there. Kindly see the business over there. If there is a business, running business, I don't know without electricity how the business was being carried out. This is one of my objection. As per their allegation, that it has been purchased in the year 2019, the flats. Second paragraph below. So far as 63 T 1T or GT road is concerned, my lord, I shall not repeat regarding that issues which are by law already decided. My lord, paragraph 5. Now he is talking about the 10 Durgadas Kuti Lane. My lord, 6329 he has applied for the inspection. Prior to that, my lord, it has to be, my lord, it's my duty to bring to you, my lord, 6323 he has applied for the new connection in year 2023. Prior to that, Milord, I don't know where from he was consuming the electricity. It has to be looked into by the CSC authority, because that was the allegation in my earlier petition, that he is consuming the electricity from the 63 and 61, which is also it's a Havra General Stores which also belong to my client, but it is the acquiring on a basis I have no any allegation regarding 63 60. If it is so, my respective submission before Lordship, that no doubt about that they have preferred the electricity. It has to be CSC has to take care of. This was the only objection, that how he was running the business.
Why did you object to their having an inspection? That would reveal everything.
Certainly not. I have not been out. I have got the instruction to my client that at the delayed point of time, the Lucky Nine Jaswal was not on the spot. He was not there. Who has objected? But I am before Lordship because it's a court where I should not. I got the instruction. Why did you obstructed? No, I was not at the delayed point. It was closed. Rather, it was closed. Door was closed. Maybe, and the meter which is in the 10 Durga Das Kotilan, that absolutely belongs to, there is no space to be asking for
Give
the
a written objection to the CSC Limited.
me.
Yes.
Yes, I have given the objection.
You got a copy of that or
Right now, I have not, but the objection which I have pursuant to my order, what I have stated to the CSA, that today I did not bring it. If you
let me hear them. Yes. Have you got a?
To take care of all the controversies, Lordship fixes a date when.
What is the tenor of their objection? I want to know that also.
I do not have a copy of the objection here with me, but I understand that we were opposed. We were not allowed to carry out inspection. So end all controversies, if your Lordship fixes a date.
No, that I'll do. That I'll do.
For
But let
inspection,
me
then-
know the basis of their objection. I mean, we have to know that also.
But your Lordship, in the earlier writ petition, I'm told that they were asked, Lordship's direction was that petitioner shall be at liberty to approach the CSC Limited with a fresh representation indicating detailed reason for apprehension of pilferage. That was not
Now
done by.
the objection has come.
Right.
I
think understand objection is here.
No, you need not. If it goes against your client, need not.
No, this
Don't
is
go by
an
Mr. Mukherjee. Yes, you check up whether it can be handed over.
We have served these copies to the CSC authority also.
Then hand over.
But unfortunately,
Is it handoverable?
Yes.
No, the copies are there. If Lordship direct.
Then hand over.
No. This is earlier when
Have the mercy to give one copy to the court also.
No, right. The original I am.
Yes.
I am sorry.
Lordship, I'm just now be instructed to state that we were physically obstructed. There was.
Please use the microphone, Ms.
Lordship, we were physically obstructed. There is probably no letter of complaint. We were not allowed to carry on the inspection. Therefore, I was stating that your Lordship fixes a date when both parties will be present. CSC will be going to carry out the inspection.
Now, Mr. Mukherjee, can you have any objection? Because they are raising an objection. They are saying the pilferage was going on from 10.
From 10 from their meter. Let it be inspected. But I do not have that. Order is already there.
Both
passed by your
inspections, same inspection, both things will be covered.
Yes, because they were also supposed to give a representation regarding the details of the
Not
pilferage.
they were waiting for this writ petition. Learned counsel for the petitioners contents that the petitioners have purchased the entire second floor flat at 10, Durgadas Kuti Lane at Howrah from the private respondent number 4. However, when the petitioners sought a new electricity connection at such premises to continue their business, the private respondent objected to the same, giving rise to the present writ petition. So next para, learned counsel appearing for the private respondent number 4 places reliance on a previous order passed in WPA 5672 of 2023 dated March 20, 2023, comma, wherein it was inter alia observed that the petitioner therein, within bracket, the present respondent number 4, bracket closed, shall be at liberty to approach the CSC Limited with a fresh representation indicating detailed reasons for apprehension of pilferage from the petitioner apostrophe S electricity connection. Full stop. If such approach was made, comma, the CSC Limited was to act in accordance with law and in due process of law and do the needful as provided under the Electricity Act, comma, 2003. Full stop. However, comma, at the present juncture, comma, the private respondent number 4 has come to know that the pilferage was definitely being committed by the present petitioners, comma, apparently from premises number 10, comma, Durgadas Kuthi Road. Full stop. Next para. Durgadas Kuthi Lane. Full stop. Next para. Learned counsel appearing for the CSC Limited, comma, on instruction, comma, submits that the CSC personnel were physically obstructed by respondent number 4 and or his men and agents when they went to have an inspection of the premises to ascertain the feasibility of giving a new connection to the petitioners at 10, Durgadas Kuthi Lane. Full stop. Next para. It is rightly suggested by learned counsel for the CSC Limited that the issues can be creased out in the event an inspection is directed to be held by the CSC Limited, comma, with police help, comma, if necessary. Full stop. Next para.
Lordship, 2nd May if possible, 2nd May at 12 p.m. if it is otherwise.
Then I'll fix that date. 2nd May, 12 p.m. Any difficulty? So therefore, no prior
No
notice.
further notice will be required.
Full stop. Next para. Since two disputes have arisen in the present case, comma, first regarding whether the petitioner is entitled to get electricity at 10, comma, Durgadas Kuthi Lane, and secondly, whether the allegation against the petitioner of pilferage in respect of the same property is
Sustainable.
is true, comma, and the issues are interrelated, comma, since the basis of such objection of the private respondent is the alleged pilferage committed by the petitioners, comma,
From his electric meter, my lord, kindly mention that.
the issues may be your
His allegation is
you're stealing it from some other meter.
Lord, there may be some other meter, Lord, standing in the name of the other occupant. His
The
allegation
entire
is,
premises they'll see.
Lord, his occupant, no, Lord, that can be looked into, but his allegation is
Comma, যেখানে
from
ছাড়লাম।
his electric meter.
The issues may be prima facie resolved if the CSC Limited is directed to hold an inspection on both scores. Full stop. Accordingly, the CSC Limited shall hold an inspection at around 12 noon on May 2, 2023 at holding number 10, Durgadas Kuthi Lane, PS and District Howrah, pin code 71101, to ascertain as to whether the petitioners are committing any act of pilferage with regard to the existing connection at such premises. Full stop. The CSC personnel shall further ascertain the feasibility of giving a new electricity connection to the petitioner, comma, as per the petitioner's application, comma, at the said premises. Full stop. A report in that regard shall be filed on the next returnable date in court upon prior circulation of copies of the same to the learned advocates for the petitioner and the private respondent. Full stop. Let us see, wait for that. The matter shall next be listed on May 8, 2023 for hearing.
Great.
So a copy of the written objection sent by the private respondent to the CSC Limited, comma, submitted in court today, comma, be kept on record.
This is the original, may I get the Xerox of that?
Take out a Xerox and file it immediately then.
আজকে দিলাম তো।
Have you got a copy? Then give a copy here and give another copy to.
Original copy, you know, I will get the Xerox and I will file in the court right now.
আচ্ছা তাহলে না ওটা না is filed না করে shall be which shall be filed by the learned counsel for the private respondent shall be kept on record. কি লিখলেন ওই জায়গাটা আমাকে একটু বলে দিন।
I'm good for that.
Shall be filed to be submitted during the course of the day by shall be থালার হচ্ছে না আরে ওটা সেন্টেন্স আবার বলে দিচ্ছি a copy of the written objection given by the private respondent to the CSC Limited shall be filed during the course of the day in court and shall be tagged with the file. Thank you.
Well, since morning I was here, I want to see SSQ Central Building code number 654. Item number 5, it has been directed to appear in the monthly list of May.
Next Monday.
Next Monday?
Yes.
Item number 5.
Next Monday is the next monthly list.
Oh,
that's not this week.
But
not this week. This week means next month.
Let it remain in its position, kindly.
Go up also. If you don't have any objection.
Otherwise, it will happen.
Otherwise, what will happen? The entire list is being called almost every day. Apart from the hearing matters. Motions are taken up every day.
Since 1 year, yeah. But I went to SSQ Central Building. That's why in the meantime, the appellate side has been taken up. But can I fix up date on 2nd May or do that?
Call on the next matter.
2nd
No.
May.
No, it will appear in the monthly list as directed.
Item 10.
Yes.
Item number 10 to 13, these are those matters. Yesterday, my lord had heard it. There were orders passed where learned advocate general appeared in a similar matter, subject to my learned friend concurring, my lord.
Mr. Chakraborty, you handed this over.
My lord, I showed it to Mr. Chakraborty and prior to my lord.
Same order.
It a copy paste it will be a copy paste order and I'm dictating the order in open court. It is submitted by learned counsel for the parties that connected appeals are pending before the concerned division bench, comma, where interim orders have been passed, full stop. Hence, it is submitted that the writ petitions may be taken up after the adjudication of the said appeals. Full stop. Accordingly, let the matters go out of the list for the present with liberty to the parties to mention for inclusion in the list after disposal of the connected appeals. Full stop. It is made clear that all questions, including the objection as to maintainability of the writ petitions, are kept open for being argued at the final hearing.
Deeply obliged, madam.
So I don't want to keep any proof of my copy paste. Take this back. Call on the next matter.
Item 14. I am for the petition.
What is the matter?
Petitioner applied for new electric connection for domestic purpose. CSC authority made inspection. Thereafter, lordship kindly sees annexure P2.
Occupancy documents, what do you have?
Yes, I have the voter card and Aadhaar card of the said.
Submit those, ownership is not necessary. What are you in respect of the premises?
Lordship, my father is the owner of the premises. I am leaving.
Yes, bona fide occupancy documents are sufficient, Mr. Mukherjee.
I have
Come to page 11.
also annexed the Aadhaar card, lordship. Annexure P1 and P2 are the voter card and Aadhaar card.
Site inspection has been completed. No point taken that there is already an existing meter.
We have, Manavi, kindly take the letter dated 5th of the February 20.
Yes,
Page
I have
11,
annexed, I
yes.
have annexed.
That is
We have
page-
asked for certain documents, Manavi, that has
See
not.
the
been-
certain documents.
I have annexed voter card and other.
They are annexing the read petition, not.
See the documents. Ownership documents, they are not required to produce.
Lordship, if they want, we will produce
Occupancy
again.
documents, definitely they'll have to produce. They have annexed the Aadhaar card photocopy.
Also voter card also annexed, Lordship. P1, page 9 and 10, Lordship.
Give copies of these documents with your application also. They have to give that.
Lordship, we will produce.
Yes, Mr. Mukherjee, what can be done?
Keep it tomorrow, my lord. Let us go through the copies. Let him give the copy.
No, he will give the copies. I'll dispose of the writ petition. Subject to giving those copies, you will give the connection.
My lord, my father, another instruction is that he is deriving supply. She is
Mr.
deriving.
Mukherjee, that has not been
They have
taken in
not alleged, Lordship.
because you have stated that as the site inspection has been completed and to enable us to proceed further in the matter. Before that, you have stated for an estimate, you are required to visit this office on any working day with these documents. So if you have held your inspection, not taken this point, how can you take it?
My lord, we direct them to give the copies. We'll upon giving the copy, upon compliance of all formalities, we will do the needful.
Lordship.
Learned counsel for the petitioner argues that when the petitioner applied for fresh electricity connection at the premises in question, the CSC Limited gave a written objection dated February 5, 2023, indicating that the site inspection was completed, but to enable the CSC Limited to proceed further in the matter, the petitioner was required to visit their office on any working day with ownership documents and bona fide occupancy documents. It is contended that the voter ID card as well as Aadhaar card of the petitioner with regard to the same property have been annexed in the form of photocopies to the present writ petition. However, it is disputed that the petitioner is required to show her ownership with regard to the property for getting electricity connection. Next para, learned counsel appearing for the CSC Limited submits that the petitioner has not produced the documents in question at the relevant juncture before the CSC Limited, for which the application of the petitioner could not be processed further. On instruction, it is further submitted that the petitioner may be already enjoying an electricity connection at the premises, which might debar the petitioner from taking a new connection. Next para. However, from the written objection given by the CSC Limited dated February 5, 2023, nothing transpires to indicate that the petitioner was already enjoying an electricity connection at the premises, nor was such ground of objection cited by the CSC Limited, although it has been specifically mentioned in paragraph number 2 of the communication that the site inspection had already been completed. Next para. In fact, the CSC required such documents as indicated in the communication to enable it to proceed further in the matter. Hence, the second dispute raised by the CSC Limited at this juncture cannot be taken note of. Hence, since the petitioner has already annexed photocopies of the voter card and Aadhaar card of the petitioner to the present writ petition, the petitioner is merely required to produce further copies of the same before the CSC Limited. Next para. In the event the CSC Limited officials seek to peruse the originals of such documents, the same shall also be furnished by the petitioner for the limited purpose of perusal by the CSC officials. Such exercise shall be completed by the petitioner within April 28, 2023. Upon such documents being produced by the petitioner, comma, the CSC Limited shall give an estimate in that regard. Full stop. Such estimate shall be given within 2 days thereafter, comma, upon which the petitioner shall comply with the formalities in law. Full stop. Upon deposit of the requisite amount of money and compliance of due formalities by the petitioner, comma, the CSC Limited shall give the new electricity connection to the petitioner at the premises within a week after such compliance of formalities. No address to cause urgent certificate.
So, only thing, one portion it has gone down a written objection by the CSC by letter dated 5th of
February.
That will be just a reply letter, where we are asked for the requisite formalities. It's not a written objection. And if my
Very good. Written objection একটা জায়গায় বলেছে ওটা কন্ট্রোল ফাইন্ড করে written objection by the CSC দু জায়গায় বলে written objection না করে written communication.
And at the existing service position. Great.
Where I've kept it open for you. Wherever you like, just give the.
No, why I'm saying in one matter we have found out that one particular these 3 words is very effective. Kindly add.
Effective for whom?
In respect of for the matters which comes up at the exist I will show in a matter that these 3 words are very much important.
যেখানে shall give connection within a week from the date of compliance of formalities at the existing meter board position at the premises.
I'm grateful, deeply obliged.
Why is it vital, Mr. Mukherjee?
Why I'm saying there are I find that since we are giving supply, somebody will object that
such and such is
that
accordingly
through
disposed of
their
without
passage
notice.
it has been given, or the property is not structurally separated. We have given in the existing.
So you keep the other objection alive.
I'm grateful.
I am for the petitioner.
Yes, what is the matter?
Lordship, petitioner applied for new electric connection for submersible pump and they are not issuing the form. Thereafter, after filing of the petition, they have issued the form to the petitioner and then we have applied in proper manner. But thereafter, they have not taken any steps, Lordship. And the application is pending.
Yes, Mr. Naik, no steps.
My lord, no steps, no application.
No.
Only later. Can I see the letter?
Thereafter, after
in
filing
that-
of the writ petition, Lordship, they have issued the form and we have applied.
That is then.
This is my
Then
instruction.
Mr. Naik, if they have applied, then process the same.
I do not know, my lord, because here in this writ petition, only one letter is annexed. That in that letter, they are saying that give me new connection.
Yes.
No form, nothing of this sort, no reference. Therefore, if any, there is cause of action, that is subsequent.
Learned
cause of
counsel
action.
for the
I
petitioner
do not know.
submits that despite having sought for an electricity connection for operating the petitioner's submersible pump, comma, the WBACDCL did not give the same for subsequent to the filing of the writ petition, comma. However, comma, it is submitted that a due application was filed by the petitioner and a quotation has been given.
No, Lordship, after application, it is pending.
Application has been filed by the petitioner, which has not yet been processed. Full stop. Next para, learned counsel appearing for the WBACDCL submits that since, comma, instead of a proper application in appropriate format, comma, the petitioner had only given a representation as annexed to the writ petition, comma, there was no scope for the WBACDCL for raising quotation. Full stop. Next para. However, comma, in the event an application is subsequently made by the petitioner, comma, the WBACDCL shall process the same. Full stop. Next
In
para.
accordance with law, lordship, because if my lord says.
Dehorza law also, sometimes Dehorza law also is written. Next.
Subject to approval of my lord.
Hence, comma, WPA 9694 of 2023 is disposed of by directing the WBACDCL to give an electricity connection to the petitioner, comma, subject to the petitioner having filed an appropriate application in proper format in that regard and subject to the petitioner complying with all due formalities. Full stop. If an application has been filed in proper format in the meantime, comma, the WBACDCL shall expeditiously raise a quotation and upon compliance of such formalities, comma, shall give the new connection to the petitioner if otherwise feasible, comma, within a fortnight after such compliance. No address to cause urgency.
Deeply opposed.
Grateful, lordship.
Thank you.
Much beyond my expectation, because you will make application, cause of action, then again, grateful, lordship.
Contempt application item 16 and 17.
For 1 week's time, my lord, to
You are
file.
for the petitioner depends on-
Alleged content, alleged contempt. Yes.
What is this?
Lift. Milord, there was, Milord, a direction.
Yes.
Milord.
Lift.
No,
No, not the lift.
Milord, there is a direction not to Milord disburse any retiral benefit because Milord, there were two Milord warring factions, two ladies were claiming themselves to be the wives.
1 week, Mr. Sengupta, please. 1 week for compliance or what?
No, no. Milord, they have already Milord flouted the order in a manner it can no more be complied with.
1
Retiral
week for
benefit.
what?
Affidavit to be put before you.
Acha, on the prayer of the alleged contemners, comma, as a last chance to the contemners, comma, the time for filing affidavit in opposition is extended till May 2, 2023. Full stop. Reply, if any, shall be filed by May 8, 2023. The matter shall be listed for hearing on May 10, 2023.
Milord, my learned friend is representing me the contempt numbers 1 to 4. Milord, there is a direction on the last occasion to serve upon 5 as well. Milord, 5 Milord, I 5 now. 5 Milord we have served and Milord, the affidavit of service Milord in terms of Milord's previous direction Milord we have filed.
Good service.
Yes.
আচ্ছা যেখানে আমি alleged contemners বলবো ওখানে
Majors personal
container
check
numbers
was-
1 to 4 হয়ে যাবে তো আরেকটা লাইন লাস্টে অ্যাড করে দিন the affidavit of service with regard to service on the respondent on the alleged container number 5 be kept on record full stop.
Served by email.
You represent them also must be.
No.
Who is that contemner?
That is the authority who's taken the money from me, who had asked me to give the money. And that matter.
But this
very
what
tough.
you are?
I am my
The employer.
Eastern Coalfields.
Employer.
Employer, yes.
Employer says, my lord, on the last occasion, my learned friend took a very fair stand. He said that the controlling authority, my lord, has issued a direction for disbursement. So, my lord, despite there being an order, my lord, passed by this honorable court, they had no other option but to disburse.
So I had appealed also, citing the order of this honorable court. They still told me to, my lord.
Put that in your affidavit in opposition.
I will.
Definitely.
Grateful. Yes.
Second.
Old matter, item 18.
Anyway, item number 18, my lord, I appear on behalf of the CSC, my lord. And I'm being led by Mr. Shannan in this. On the last occasion, KMC has given us a report. Mr. Ghosh is there.
Yes, I'm
Well,
led by
will your
Mr.
lordship be
Ghosh. I am for
kind
the
enough to take
petition.
it up tomorrow?
Mr. Which goes
Gopal Chandra Ghosh.
tomorrow?
Mr. Shannan, is there. I don't find from KMC also.
KMC has filed its report.
We
How do you
intend to-
expect the KMC to be present after that?
We intend to file one exception to the.
Was there any direction?
No, my lord, there is no.
Have you given a copy to the KMC advocate?
No, I'm giving it here and now.
I'm not.
You are for the petitioner.
I'm for the petitioner.
Here and now you cannot give.
No, because KMC is not agree.
Very well. Learned counsel for the petitioner seeks to file an exception to the report filed by the KMC. Full stop. Let a copy of the same be circulated on the learned advocates appearing for the CSC Limited and the KMC by tomorrow. Full stop. The matter shall be listed for hearing on April 28, 2023. Friday. I've given you till tomorrow, but try to do it today. Him you can serve today.
Grateful.
Thank you. Please give your name. Yes.
Item 19.
And in this matter, I am appealing for the petitioner, my lord.
Right.
My last occasion, your lordship directed my learned friend to file affidavit in opposition within 17th and reply, my lord. My lord,
Can I-
they have filed, my lord, the
The
affidavit, my lord, on 28th, my lord. Your lordship kindly give me 7 days time more, my lord. Next Tuesday, we shall file our reply, your lordship kindly.
Affidavit in opposition filed today be kept on record. Full stop. The time for filing reply is extended on the prayer of learned counsel for the petitioner till 1 week.
And next Tuesday.
Next Tuesday. Till May 2, 2023. Full stop. The matter shall be listed on May 3, 2023.
I'm grateful.
I'm
Thank
দু তারিখের মধ্যে ফাইল করতে হবে 3 তারিখে আসবে নামগুলো কি
একজনই ল্যাপটপ
For hearing, item 20 and 21.
Lord, I am for the petitioner.
I'm in item number 20,
Ah,
I'm appearing for the WBSC.
Well, the last occasion.
20 lordship appeared.
Last occasion, your lordship liberty was granted to file a supplementary affidavit. The annexing the photograph of the. Photo copy का नहीं?
Opposition. You are appearing for the
Private respondent number 6, the landlord. Yeah.
Both the matters.
Petitioner.
Is the opposition. Supplementary affidavit is being filed only in WPA 1812.
Another matter, my lord, there is also another.
Two are being taken up to
1812, my lord, I have
Last election.
a supplementary affidavit. There was no direction.
Lord, I produced before the court this photographer. Your lordship want to file a supplementary affidavit to have it in the file. For that reason, Lord, I am filing this supplementary affidavit for.
Have you given copies to them?
Your lordship direction only opposition and reply. Opposition reply has also been completed.
No, there is no direction for supplementary affidavit, sir.
Well, for this photo.
No, for whatever photo, there was no direction.
Your
Must be
lordship-
Mr. Pandit's brainchild.
Your lordship has said, therefore, Lord, I.
Anyway, I'll permit you, but give them copies then.
Yes, Lord, I shall give copy.
Very well. Reply, what about reply?
Yes, Lord.
Reply you're filing.
This is the reply.
Both the matters.
Both the matter, yes. Yes, both the matter.
Affidavits in opposition and reply filed today be kept on record. Full stop. Let copies thereof be circulated in between the learned advocates for the parties. Full stop. On the prayer of the petitioner, comma, the petitioner is permitted to file a supplemented affidavit which is kept on record. Full stop. Let copies of the same also be circulated to the learned advocates appearing for the other contesting parties in both the matters. Full stop. The matter shall next be taken up on. When should I keep it for your perusal of the supplemented affidavit, Mr. Naik's and yours?
Next week, my lord.
Next week.
Next week.
Give me a date. Suits all of you. Yes, Mr. Chatterjee.
But reply has not been given to us.
Hello.
Will be given. Will be given.
বলেছিস যে কোর্টে যে নিয়ে নেবো কালকে গতকালই বলেছি কোর্টে যে
আরেকটা সাপ্লিমেন্টারি
আমি ওকে বললাম যে দিয়ে আয়
সাপ্লিমেন্টারি এফিডেভিটস হবে
I have given to them.
কোন নাম্বার বলেছি
Private respondent I have given.
Supplementary affidavits.
Private respondent.
Oh, private respondent.
The matter shall next be listed. Next be listed on
Supplementary affidavit.
May 3, 2023 for hearing. I have directed copies to be circulated of the reply also.
It's not a very
No, 3rd May.
সামান্য কেসটাকে নিয়ে
3rd May.
very hard
Next week?
issue is not involved, my lord. Line to be given, we are willing.
Who is not willing?
Not willing, that they the landlord. He has filed a suit for eviction us. They want to.
Such infrastructure.
Yeah, yes, there is an infrastructure. How they have said.
Very well, lordship, can't tell, madam.
How they have
Come back on 3rd May. Let us see.
Thank you.
22.
My application.
Yes.
Pleadings have been completed with respect to respondent number 5. Your lordship would recall, Mr. Rashid was appearing for the private respondent. He wanted to file an affidavit in opposition.
Right.
With respect to the point, this was for security deposit and the refund thereof. My application. Petitioner, sir. Lordship would recall. Lordship would.
I only recall that you had vehemently objected, but what was the objection? I forgot.
I'll.
My lord, if I can have filed.
I'm led by Mr. Banerjee.
Yes. Yes, Mr. Banerjee, what was the dispute? I'll come to you, Mr.
That the dispute was with regard to return of the security deposit that I had made. I'll address it in 4 questions. Who am I? What is my right? What is the breach? What is my remedy? If the private respondent can, locus I really can't raise anymore, but can have a legal objection to this remedy in my favor. Now, who am I?
Oh, that.
Yes. Who am I? I was an existing consumer of the respondent authority. After that, by way of a surface sale, private treaty, whatever, it will become irrelevant. By way of, I will not take much of your lordship's time. No? I will
take your time, please.
But by way of a private treaty, this was sold to the private respondent. The cold storage was sold to the private respondent. The electricity connection or the consumer also changed from me to the private respondent. The amount of money that I had given as a security deposit for supply of that wattage of electricity to me, that I've asked for a refund.
The surface sale, you said?
It was surface sale. That was
You are the borrower.
I was the borrower. There was a default. There was surface sale.
So you want back your security deposit?
I want back my security deposit. The authorities say you're entitled to a security deposit. We will give it back to you, but we are not being able to give it to you because the private respondent has come and put an objection. So I implead the private respondent. I show that particular regulation by which I'm entitled to refund of a security deposit. Private respondent comes and argues, I want to bring on record certain documents primarily to show that the the sale was on as is where is basis. This is his case in his affidavit in opposition. The sale is on an as is where is basis. The sale is by way of a private treaty. The security deposit that the petitioner that I had given gets adjusted with the security deposit that he has given. And thereafter, after the adjustment was the sale on as is where is basis. In the sale by memorandum, this was a private treaty which gets sanctioned under the Surface Act. There is nothing with regard to refund of the security deposit to me, the petitioner. Therefore, I am not entitled to claim that money back from the authority. Now, 2 things I'll have to show to your lordship from the writ petition first, my right. And secondly, this objection that's been taken to kindly have a look at the writ. my junior is right. The ground on which they got the scope for filing an affidavit was they said that the security deposit that was mine, it got transferred to them. I incorrectly used the word adjustment. Their case was it got transferred. That is the case that they make out in the opposition also. Thankfully, with these documents, that the pleadings get completely belied. But I'll still first show from the writ petition. Kindly have a look at page 26.
Yes. You placed that on the last occasion. WBSCDCL asked the original receipt.
That's right.
From
So
only that.
WBSCDCL really is not contesting it, saying that we are not liable to refund it. And they don't say it because of this. I'll just show the particular clause. Kindly have a look at the regulation.
What is the regulation number?
4.2.5.
No, the regulation notification number.
Well, I'll hand it over.
No, just tell me that.
I will hand it over. Notification dated 2nd April 2013. May I hand over a copy?
Supply code?
No. This is the West Bengal Electricity Regulatory Commission. Regulations 2013. Possible, kindly come to 4.2.5.
Yes.
The security deposit shall be appropriately returned or refunded within 15 days on the request of the person who gave such security deposit after adjusting amount of any outstanding bill. It's nobody's case that there is any outstanding. So in fact, that 4.2.5 does not apply to me. That's not the stand of the authority. It's only the private respondent who comes and says that because of a particular private arrangement, they are not, authority will not give it to me. I am not entitled to take it back from the authority. Now, my Lord, Lordship, this is so far as the writ petition is concerned. Now, kindly have a look at the affidavit in opposition once. Okay. Yeah, I'm at a note called opposition. Yes, we'll have a look at the opposition one. Well, the case made out is, if I could show just that one pleading, initially, your Lordship will find pleadings in the opposition, which talk about the sale that happened between me by way of private treaty and the private respondent under SABYASACHI. In my respectful submission, that is irrelevant. My learned friend relies on an agreement. That agreement also says nothing about electricity security deposit, nothing.
Agreement between whom?
Me and him, by which initially the sale was set aside. Then we entered into a private treaty under the SABYASACHI Act because there was one bidder. So by a private treaty, the sale was held.
So ultimately, it was not a SABYASACHI sale.
It was a private treaty under the SABYASACHI Act, following the Siddheswari Cooperative and all of that.
Very good.
It's under the Act only. The Act recognizes a sale by private treaty. If there are certain conditions which are there, that private treaty was done between me and the private respondent, it was sold. Now his case, your Lordship will see. Kindly have a look at first few paragraphs of the of his opposition. Paragraph 8.
Yes.
Thereafter, by letter dated August 29, 2014, the respondent number 5 informed WBSCDCL to change the consumer name as Ma Annapurna in place of Singer Korma, this is the petitioner, and Agro, thereby having consumer number so-and-so. In response to the same, by letter dated November 8, 2014 was sent to respondent number 5 by WBCTL. Kindly mark this, asking us, that is a private respondent, to furnish further security deposit of rupees 1218, which the respondent number by way of bank guarantee, as earlier security deposit was already lying as cash security. So admitted today that when he asks for his consumer number and for supply to him, WBCD SEDCL requires a fresh security deposit to be given. The security deposit was of 1218, which again admittedly he has paid. Now the story of adjustment. Now your lordship will have a look at the document that he's annexed. Lord, kindly have a look at page 41 onwards.
Yes.
টেনটা পরে দেখাচ্ছি। Yes, 41 onwards your lordship will kindly see. ওই চিঠিটা বার করো যেটা আছে যে সিকিউরিটি ডিপোজিট বেশি ধরে আছো। Lord, why I want to show this is your lordship will see the supply contract demand at the top. Top right hand column, contract demand KVA 200. Because the security deposit is actually calculated on the percentage of the demand of the, so this will be relevant. This your lordship has seen at page 41.
This is your original application.
This is his bill that is coming. Now your lordship will kindly have a look at page 26.
Yes.
This is WBSEDCL writing to the private respondent. Date is 9th of June 2015. Subject, refund of excess cash security over estimated deposit for 2015-16 against bulk supply to the private respondent. Kindly marks this. We like to invite your attention to the fact that the billed amount estimated on the basis of average consumption of electricity at your above premises based on 12 months consumption of the previous year as on 1st April 2015 is rupees 415,653. The amount of security deposit for the supply held by WBSEDCL is indicated below. Amount of SD already held by WBSEDCL as on 31st March 2015 before interest. Bank guarantee you also will find at the left hand column. And cash, which is my figure.
Which is?
My figure, my amount that is with them. Then kindly have a look at the next one. Interest on cash as on 31st March 2015. Well, the regulations provide that if you are withholding a security deposit beyond what you're entitled to, you have to provide interest on that. That is 4.2.6. Now, interest on cash as on 31st March 2015. So the cash deposit interest is rupees 65,348. Closing balance again as on is 1218 and cash is this. From the above, it is seen, kindly mark this, that the present amount of security deposit furnished by you is more than sufficient and the excess amount payable to you as per clause 446 of West Bengal Electricity Regulation Commission Regulation 2005 in connection with the supply is given below. Amount of security deposit for 1 year is 1254. Amount of SD already held as on 34 is 24. And refund is the cash security deposit amounting to 65 will be adjusted subsequently in the energy monthly bills. So my learned friend's client has given his own security deposit. On top of that, WBSEDCL is holding my security deposit. WBSEDCL holds that what is required is 1254. What is with it is 24. And on this excess amount, they're paying interest. Now, why does the private respondent not want this money to come back to me? The bills that is annexed show this. Every month, this excess interest that he gets on my money that is held gets deducted from his bill. And do not rely on me for anything I argue, because the documents will show what I'm saying. I'll show the document. This is why he is coming forward and saying, so the story of adjustment is absolutely incorrect, because page 26 clearly reflects that the amount of security deposit that is being held by the respondent authorities is twice over than what is required. And this difference between what is held and what is required is actually my money. This private respondent today can't come and say that I will not let an authority refund the amount to you in discharge of its obligations under the regulations, where interest is being paid by the authority and being enjoyed by the private respondent. And I'll show that. Now, kindly turns to the next page once. Page 27. Statement of security deposit for the financial year 2014-15 based on 12 months consumption of the previous period as on 1st April 2014. Your Lordship will find total estimated consumption, then KVH
When did the sale take place, Mr. Banerjee?
Sale took place from 2015, they take over. And this document, I'm just showing 27, he's annexed, thankfully, series. It's still continuing. Look, this page, Your Lordship will kindly see. At the right-hand column, bottom, sufficiency of estimated security deposit for 20.
Page 27.
Yes, 27 at the bottom right-hand corner.
Yes.
Sufficiency of estimated security deposit for 2014-15 with respect to security held by. Current held security deposit 24,288. Current new security deposit. Current interest amount 72,650. TDS, current interest payable, is 63. If Your Lordship corroborates this with 26, the interest is being paid on the excess cash security held. The cash security is mine. So every month, now if Your Lordship keeps turning over, just gives it a cursory glance, not every month.
But Mr. Banerjee, 4.2.5 says it will be refunded after adjusting amount of outstanding bill. Now, there was outstanding bill on your part for which it was disconnected initially. Was it disconnected? No.
No, there was no disconnection. There was outstanding bill which the bank paid off for 3-4 months.
So by the same logic that you are wanting back your security deposit, this portion of the clause also applies, that adjusting amount of any outstanding bill, whatever was outstanding from you, they are entitled to adjust. And if they adjust, then these people will get the advantage naturally.
My Lord, page 26, Your Lordship has seen.
Yes.
What is excess is today quantified. What is excess?
Now you are wanting refund.
I want that
previously
excess.
There was no scope of refund. If they have to refund, then Mr. Banerjee, they have to adjust this amount of outstanding bill also.
Then Your
left by you.
Had to be. Now Your Lordship has seen page 26 of my writ petition.
Yes.
There's no one letter from WBSCTCL that there is outstanding
But
for
the same law which you are relying on, Mr. Banerjee, says so.
Says so. For that,
I can direct the refund after adjusting the outstanding amount.
No, there was no outstanding amount on my part. This has not been, and if there has been at all, then that can't be recoverable from me today because of 56(2). But I don't want to argue it.
No, after the contract with you terminated after 180 days from disconnection, if there was disconnection.
There was no disconnection.
At any point of time.
But it was just transferred from me to him. It is also not WBSCTCL's case. WBSCTCL does not come before Your Lordship and say there's outstanding amount. We are adjusting it against it and we are going to refund. They are saying it's entitled. I'll show Your Lordship that letter. You are entitled to refund.
Here is the shoe pinches, their shoe pinches, because of the reason, whatever amount if to be returned to you upon adjustment of that outstanding amount from you, if that be so, then that will help them insofar as the security deposit increases then.
Well, I'll tell you, Lordship, where their shoe pinches. Their shoe pinches because of the next page. Every month, Your Lordship will see that the amount of interest that they are enjoying from my excess security deposit is getting deducted from their bill.
I'll direct them to whatever outstanding dues are there, subject to hearing all friends. I'll direct them to refund it after deducting the outstanding dues.
So
from you.
there is no outstanding. WBCDSL, even on the last occasion, they've not filed an affidavit.
So never, they did not file it, ask for an outstanding.
Never.
At any point of time.
There is, that clause would of course apply. If I have
Very well, I get your point. So then that does not apply. It has to be a refund.
That's all. Well, it is nobody's case. It is not the authority's case.
Right.
It is well, it is not the authority's case that I'm entitled to it, but there's an outstanding. The outstanding subsumes the security deposit. No, or that the outstanding and then the remaining.
BHATCL has no case made out.
No case because there is no outstanding. My lord. They don't make
But
out.
they
the
never
case.
allege. No, if they
And
don't
they
allege,
also can't take a stand contrary to the document that my learned friend has brought on record. It has been now held in that page 26 that the amount of security deposit actually in excess. Now, one regulation your lordship will see.
so if they had to deduct, while giving this before giving this interest.
That's right.
Very.
I am extreme. That's why I would have shown that. That I am extremely grateful.
Which clause? The clause you placed.
Clause in the regulation. That
Yes.
interest is. I'm very, very grateful.
So show me that clause.
I'll show that clause because interest is payable on what is refundable. আচ্ছা সিকিউরিটি ডিপোজিট টাকাটা কত টাকা হবে সেটা দেখো আগের দিন দেখতে বলেছিলাম এই তো এখান থেকে দেখো 4.2.6 how is security deposit calculated 4.2.6 the distribution licensee shall pay interest on cash security deposit equivalent to 6% per annum. Such interest shall be computed annually and added to the security deposit held against the consumer as long as the security deposit thus held is less than equal to the amount of required security deposit, provided the excess interest amount shall be annually refunded or adjusted to the consumer in that event. The security deposit amount is already sufficient or becomes sufficient in the billing month of May of each year. So this cash security interest is being paid.
Yes.
Now,
rather you are entitled to get 10% interest per annum.
Now, your lordship will just have a look at. That's just the one. Electricity Act, section 47.
47(1).
No. I'm sorry, Manoj. No, there is a clause that I had seen in the regulation that provided for how much is going to be the security deposit.
Yes.
And I'll just indicate that if your lordship gives me 2 minutes, Manoj. I can't find the note that I had made. Just gives me 1 minute. Manoj. My learned friend can address your lordship. Yes. 4.1. 4.1 of the regulation. Achha. 4.1, subject to the provisions of the Act, the distribution licensee may require any person to give security deposit with such licensee for an amount covering 3 months of estimated bills of consumption of electricity at the prevailing rates. The estimated consumption shall be based on 12 months consumption of the previous period as on 1st April of each year, or estimated consumption based on his application in case of new applicant. Provided that in the case of a new applicant, the estimated consumption based on his declared load shall be treated as an advance, which shall be appropriately adjusted with the amount of security deposit, which would eventually be determined on the basis of the first 12 months consumption when the latter time period is over. No, why I wanted to show this is to show that when they require security deposit to be given by the private respondent, the requirement is only of 12,18,000. That 12,18,000 is calculated in terms of 4.1. So the remaining cash security that is held is beyond the requirement of 4.1, which is why the WBSCDCL in that document at page 26, this one last document I'll show and I'll rest my case. Manoj. Kindly now once more comes back to page 26.
That communication of 9th August, 9th June.
9th of June.
Yes.
At the bottom, amount of secure deposit for the year 15-16. Amount of SD already held as on is 24. Now, if your lordship corroborates this with that document, which requires them to give the security deposit, which I had placed at page 15. This is to the private respondent. In response to your letter under reference, this is to inform you that on the basis of your prayer, as well as submission of documents, you have to execute fresh agreement with WBSEDCL for contract amount of 200 kVA.
That entire bank account is bank guarantee is there already.
That's right. And the amount that they want
Let me hear Mr. Khan now.
is 1218. That's all.
Yes, Mr.
My lord, kindly, if my lord comes to page 12, my lord.
Of
affidavit in opposition, my lord. Last day I've showed you, this is the first document, my lord. Why I'm claiming this amount, my lord. When the bank took
First formulate your point, Mr. Khan, then place it
my
up.
lord.
Just tell me what is your defense.
My lord, in this, when bank took possession, my lord, bank wrote to WBDCL that the security deposit which is being held by WBDCL should be kept on hold till the dispute between the petitioner and the bank is sorted out. Thereafter, my lord, if my lord comes to page 13, there was a sale done. The sale was done by bank on as is, where is, and whatever there is basis. So that security deposit.
The entire thing merged into your private treaty.
My lord, no, my lord, this till here they were opposing the sale, my lord. Here
that chapter is closed now.
Then, my lord, no, when the sale took place, my lord, we applied for the transfer of the meter in our name, my lord. When we that is in page 15, my lord. Then we provided the bank guarantee. My lord, kindly see page 26, which they were showing. Kindly see the date, my lord. This is on 9/6/2016, my lord. This date 15, sorry, my 9/6/2015. This date is very important. The bank guarantee, see the total amount, 24 lakh, whatever it is, my lord, 12 lakh of theirs, our bank has been transferred to Ma Annapurna Sheet, my lord. And then the private treaty.
Where do I get it? It was transferred to you.
My lord, to Ma Annapurna Sheet.
And they do it. Their security deposit, how can they transfer to you?
My lord.
I'm telling you. Please come to page 15 once.
Page 15. Yes, ma'am.
There is no reflection at page
24 lakhs, my lord.
There is no reflection at page 15, Mr. Khan, as to the total security deposit required being more than 1218. The entire security deposit, they asked you to furnish security deposit for rupees 12,18,000.
My lord.
In respect of which you have given a bank guarantee.
Bank guarantee.
So that chapter is over.
But
their entire claim is security deposit is 1218.
My lord, but
so how can they exceed that and give you interest on that?
My lord, but they were they have whatever they have done, that's their Mr.
They'll have to give 10% interest now.
My lord, whatever they have done, they have transferred it to us. Why? I'm telling, kindly come to page 36, my lord. This is very important, my lord. 36.
Yes. Why is it important?
This is the letter where they have proposed for the private treaty. This is on 4/3/2016. This is after that 24 lakh, that 12 lakh was transferred. A total amount of if you come to page 26, you see bank guarantee of 12,18,000 and cash security of 12,10,000. Total of 24 lakh was transferred to Ma Annapurna Sheet, that is as my lord. And thereafter, this private treaty comes, my lord. So they were when they.
What was the occasion for your application and that being entertained? You're giving after the surfaces sale.
My lord, that sale was set aside. They have challenged my.
No, before setting aside of that sale, this happened.
My lord, that is what.
Fund of excess security.
My lord,
this was prior to
that, and they,
private treaty.
Prior to private treaty, my lord. Thereafter, private treaty happened, and then again.
See any reflection in the private treaty in this letter?
My lord, see page 39. Kindly, this is the sale.
39.
39, my lord. This is the sale certificate. This is whatever, that is.
Also, you say as is where is has to
Whatever there
include.
is, because the bank has withheld that security deposit when bank took possession, my lord. The first document I have shown you, my lord. That security, when we purchased, my lord, that there was never the security deposit was never released, my lord. Because that even the dues were adjusted, including the security deposit. And
no, that's the incorrect fact.
my lord,
Well,
even
you'll get your chance. Yes.
my lord, and if my lord comes to page 41,
Mr.
kindly.
Khan, then according to you, the sequence of events is this. They deposited security deposit, they got that electricity initially. Subsequently, it was transferred to your name.
My lord.
Now, it was transferred to your name. At that point of time, the private treaty had not come in.
My lord.
At that point of time, only the sale certificate was, the initial surface sale was there,
My lord.
which was subsequently set aside. Now, during this interregnum, before that private treaty, all these communications took place.
My lord.
So at that point of time, you say that your bank guarantee of 1218 plus that 1210, that was given adjustment, and 1218 was claimed for.
Why, my lord?
After that, this private treaty took place,
My lord.
as is where is basis.
And whatever there is basis, that is also.
And whatever there is of basis.
And my lord, very important, kindly come to page 41. Why this all happened, my lord? Till the actual sale in 2000 took place, the property belonged to
Give
them.
me the dates. Give me the date of the surface sale first, the initial surface sale.
11/8/2014. Bank
Initial one.
Bank took possession on 25/6/2014, my lord. Bank
Sales
took
certificate, what is the date of the initial sales certificate?
11/8/2014. First sale certificate, my lord. 14.
Yes, then.
Then, my lord, we asked for the change of name, my lord, that we have applied in 26/5, that we have applied on 08/11/2014. We have given bank guarantee on 26/3/2015.
So that chapter closes after your 9th of June 2015 letter.
My lord.
They adjusted whatever they had to do. After that, the private
treaty comes in, my lord, and sale certificate issued thereafter on 11/3/2000.
Well, placing this letter at page 36, why?
My lord, this is their communication to us. This is their proposal for the private treaty to pay us, pay 5 crore.
Portion helps you, Mr. Khan.
Our proposal to UBI for a one-time settlement of loan with a conditional sale on the said cold storage by way of private treaty, my lord. This is the private treaty subject, my lord. They have proposed us to go in for a private treaty, my lord. And thereafter, my lord, the sale certificate was issued on.
Mr. Khan, let us come to the penultimate paragraph of page 36.
My lord.
Please place that.
My lord.
The second last paragraph of page 36.
My
Please read that out.
The settlement amount has been quoted as rupees 664 lakhs, wherein you are required to make a payment of 554 lakhs, in lieu of which we shall give our assent to proceed with the sale by private treaty in your favor. The balance amount of rupees 110 lakhs shall be paid by us directly to the towards full and final settlement of the loan.
So the agreement was you have to pay 554, they'll pay 110.
My lord, but the security deposit bank has withheld, my lord. That the first letter I have shown, that is very important, my page 12, my lord. This entire thing, my lord, bank, whatever the adjustment bank is doing and selling it, this includes the, and there, that is why, my lord, kindly come to page 41. This page 41, my lord. These are the bills from 28 August 2014. This is in the name of the petitioners. These bills we were paying. Why, my lord? Because we knew, otherwise we would have adjusted the security deposit, because the security deposit was transferred and withheld by the bank. Then why will we pay till we took the sale took place in 2016? Before that, any liability that is there, be it electricity, whatever, we were paying because the security. Page 12, my lord. That is the. If bank would have not stopped the security deposit, then my lord, there was no issue at. Bank has specifically said that the security.
Anything else, Mr. Khan? I've got your point.
My lord,
This is all. Yes, Mr. Kole, what do you have to say? The
That
WBC.
is like, exact fact is this, my lord, initially.
You are siding with whom?
No,
No, I mean the WBSCDCL is siding with.
Your lordship's my lord retired.
No, no. According to you, who should get it? I mean, you should refund it to them. You are agreeable to do that.
Actually, what has happened, my lord,
Please use the microphone, Mr.
initially in the year 2014, the United Bank wrote us, don't release the security amount. You please
on
release
that.
us the
Yes.
bill.
Yes. Whatever may be the previous reasons, Mr. Kole. As per law, what is your liability? To pay back to them.
That is, my lord.
If you pay back to them, then what will be the consequence? They will have to put in further security deposit.
Yes. No.
my lord.
Yes, 24 lakhs. Because of the outstanding dues they have paid and they have raised objection, since we are paying outstanding dues, don't release the security amount in favor of the batch. If we release, my lord, they will have to pay again another security.
Very well. Yes, Mr. Banerjee, what is your reply?
Two things, Manoj. First, I'll start with what WBSCDCL said. There is no letter requiring the private respondent to make payment towards any outstanding dues. There is nothing written by the private respondent to the WBSCDCL regarding outstanding dues. There's no.
Because already paid. That's why, my lord, there is no letter.
That is also
Bank.
not reflected from, there is nothing on record. The private respondent has filed that affidavit. I don't know why.
Mr. Banerjee, explain to me the chronology of events. On 9th of June 2015.
No, there is one more important date before that.
What?
Real sales certificate that happened in 2014. Your Lordship asked a very pertinent question that all these documentation regarding them writing to them for Singer Cone transfer, how did it precede the sale?
No, that was the surface sale.
That's right.
The regular surface sale.
It is by way of a regular
subsequently
surface.
that merged with your, because you gave an offer on the basis of as is where is whatever there is basis.
Yes.
Now, if that be so, that basis has to be counted from your offer date.
My lord, now two things. The sale happened under SARFAESI on 11th of August 2014. Based on that sale, they go into possession of my cold storage. They apply for a meter in their name in the cold storage. They take the consumer supply in their name in the cold storage, giving security deposit for that. That is the document on record.
That is the 9th of June 2015 document.
At their page 18 and 15. And this date will be very important. This adjustment story, whatever, if he is at all entitled to recover any money from me, he will have a different forum in law to do. When I am praying for disbursal in terms of a regulation framed under a statute by a statutory authority, the statutory
regulation, they are going as per regulation. They are saying the outstanding amount has to be adjusted. That is the only thing.
That is also not the case of WBSCDCL. Not one letter is before your lordship saying there was any outstanding payment or that they have, this is a completely malafide submission that they made payment of outstanding dues. Your lordship will see 8 November 2014. And the date is so important. This is 8th of November 2014. So this entire arrangement that they talk about is belied by this letter. This letter says that for supply in your name, and execute fresh agreement. This is not a case of transfer. There is a distinction in law between my getting merged with his or my connection being transferred to him. The requirement is to execute a fresh agreement with WBSCDCL for a contract.
So you say that if at that point of time, even
That's
before
right.
this purchase treaty, everything, their claim was restricted to 1218. So they cannot exceed that.
They cannot exceed that and have two things, Manoj. One is 1218 is the requirement under law for the supply to them. 2, 1218 has been paid.
That is why the 1210, your 1210 was being treated as excess and interest.
And interest is being paid on that. From that interest, he is benefiting today, therefore he does not. That is where his shoe pinches.
What is the other thing, Mr. Banerjee?
This,
Two things.
I don't,
These are the two things.
I'll add one more because your lordship has given me the chance. I don't need to address your lordship on this because I don't think it's relevant in
Don't
this.
address. Then don't address.
Just still, your lordship's
necessarily
attention has been,
related.
page 39, kindly have a look at.
39 years.
A lot of reliance has been placed on this as is where is.
Has been, yes.
What is being sold on as is where is? The sale, last two lines, the sale of the scheduled property is made on as is where is basis free from encumbrance, and the scheduled property is given.
That free from encumbrance is crucial.
That would have been.
No, it becomes crucial, but you say there was no encumbrance, other encumbrance.
That there,
I mean, this was not an encumbrance.
This was not an encumbrance.
Very.
And an as is where is basis, in respect of an immovable property, is with regard to.
Mr. Banerjee, no further reply.
No further.
Only Mr. Khan answer one question. Only one question, you reply that, and Mr. Banerjee will not further answer to that. Please take your seat, Mr. Banerjee. Yes, Mr. Khan, what is your answer to this? 8th of November 2014, at that point of time, WBACDCL asked for a security deposit of 1218. Then at that point of time, that must have been a security deposit, required security deposit. So how can you enjoy the excess 1210?
My lord,
They have shown the breakup, they're paying interest to you on
my
that.
lord, that is why
So that they have to be restricted to the 1218.
my lord, that is why page 12 is very important. My lord, page 12, that is that last.
Why is it important? Tell me.
My lord, we hereby request you to kindly dispatch the monthly electricity bill in the address of the cold
Cannot
storage.
calculate on that.
My
Mr. Khan, only show me one place where they have claimed security deposit of.
My lord,
I've not finished, Mr. Khan. Show me one place where they have claimed security deposit of rupees 24 lakh. Show me one place.
My lord, they have not.
Entire time they're asking for security deposit is 1218.
My lord, this security deposit, why the bank withheld? Because, my lord, from page 41, if you see, we were going on paying the bills, my lord. That time, like, page 41, every month 4 lakh.
And I've got my answer. Let me pass me out.
My lord, every.
Take it.
My lord,
the petitioner contends that the petitioner, at the initial juncture of taking electricity connection at the premises in question, had deposited security amount, roughly to the tune of rupees 1,210, 831.04 p. Footstep, next para. Subsequently, the petitioner was unable to repay a loan taken from the bank, for which the property in dispute was sold by way of a surfacey sale. Footstep, such sale took place initially on August 11, 2014. Footstep, thereafter, however, the petitioner challenged the sale, and ultimately there was a private treaty between the petitioner and the subsequent purchaser, that is the private respondent number 5. Footstep, pursuant thereto, a new electricity connection was given to the private respondent number 5. Footstep, however, subsequently, when the petitioner asked for refund of the security deposit initially given by the petitioner, although the WBACDCL was agreeable to refund the same, subsequently the WBACDCL did not refund the same on the pretext that the private respondent number 5 is claiming adjustment of such amount with the security deposit put in by the private respondent. Footstep, next para, learned counsel for the WBACDCL takes a stand that the WBACDCL, in principle, has no grievance if the amount of security deposit put in by the petitioner is to be refunded. Footstep, however, upon query of court, learned counsel for the WBACDCL submits that in such event, the balance security deposit to be refunded has to be compensated by the subsequent purchaser, that is the respondent number 5. Footstep, next para, learned counsel appearing for the private respondent number 5 points out that at the time of entering into the private treaty, it was specifically agreed between the petitioner and the private respondent number 5 that the property would be sold on within double inverted as is, where is, and whatever there is, double inverted close, basis. Full stop. Hence, comma, since prior to such date, comma, the WBSCDCL had already given adjustment to the security deposit previously put in by the petitioner with the security deposit payable by the private respondent number 5 at the time of giving the electricity connection, comma, the expression within double inverted as is, where is, whatever there is, double inverted close, includes such liability to pay the amount of security deposit, comma, which has already been adjusted. Full stop. Hence, comma, it is argued that there is no scope of refunding such deposit, comma, which has already been adjusted with the payable amount by the respondent number 5, comma, to the petitioner. For sub next para, upon a perusal of the materials annexed to the present petition and the connected affidavit in opposition, comma, it is seen that the initial certificate of sale in favor of the respondent number 5 was dated August 11, 2014. Full stop. Next para, contemporaneously, almost contemporaneously with such certificate of sale, comma, by a communication dated November 8, 2014, issued by the WBSEDCL to the private respondent number 5, comma, it is clearly disclosed that even as per the licensee, comma, the respondent number 5 was to furnish security deposit of rupees 12, 18, thousand, calculated as per the then latest tariff on 200 kVA in the name of the respondent number 5. Full stop. Next para, subsequently, comma, in the communication dated June 9, 2015, comma, it is seen that the WBACDCL admitted that the total amount of security deposit lying with the WBACDCL was the sum total of the bank guarantee furnished by the private respondent number 5 to the tune of 1,218,000 and the cash security deposit which had been previously made by the writ petitioner to the tune of rupees 1,210,831.04p. Full stop. Next para. It was further indicated by the WBACDCL that the security deposit furnished was more than sufficient and the excess amount was payable to the private respondent number 5 by the WBACDCL. Full stop. Next para. Even from the subsequent electricity bills raised by the WBACDCL with regard to the property, comma, it is disclosed that the WBACDCL went on giving adjustment by way of interest for the excess security deposit lying with the WBACDCL. Full stop. The communication to the respondent number 5 made by the WBACDCL on November 8, 2014, comma, read in conjunction with the communication between the same parties dated June 9, 2015, comma, clearly discloses that the total security deposit sought from the respondent number 5 by the WBACDCL for giving the new connection to the respondent number 5 was rupees 12, 18, 000 oblique dash. Full stop. Thus, comma, there is no scope of there being any further outstanding amount which was never, comma, in any event, comma, indicated by the WBSEDCL on any previous occasion. Full stop. Hence, comma, admittedly by the WBSEDCL, comma, the cash deposit of rupees 1,210, 831.04p given by the petitioner was lying as excess, comma, for which interest was being disbursed in favor of the respondent number 5. Full stop. However, comma, since the respondent number 5 did not have any further claim against the petitioner, comma, nor did the WBSEDCL have any claim on the excess cash deposit which was still lying with the WBSEDCL, comma, deposited by the petitioner, comma, there could not have been any occasion of the respondent number 5 being unjustly enriched by the interest being paid by the WBSEDCL in each billing cycle on the excess deposit which was lying with the WBSEDCL. Full stop. Next para. That apart, comma, learned counsel for the petitioner has rightly contended that clause 4.2.5 of regulation number 52 dated April 2, 2013 of the West Bengal Electricity Regulatory Commission, WBERC, stipulates specifically that the security deposit shall be appropriately returned stroke refunded within 15 days on the request of the person who gave such security deposit after adjusting the amount of any outstanding bill. Full stop. Next para. In fact, comma, clause 4.2.6 of the same regulation stipulates that the non-refund or non-adjustment of the interest on security deposit to eligible consumer shall attract interest at the rate of 10% per annum in addition to other penalties, etc., as per the provisions of the Act and regulations. Full stop. Next para. In view of the above discussions, comma, the petitioner is squarely entitled to get back the refund of the excess security amount which was lying with the WBSEDCL at the behest of the petitioner. Full stop. Since the petitioner is no longer a consumer and the contract between the petitioner and the WBSEDCL has terminated for all practical purposes, comma, it is the bounden duty of the WBSEDCL to refund the amount of rupees 1,210, 831.04p to the petitioner in terms of clause 4.2.5 of regulation 52. Full stop. Next para. Insofar as the interest contemplated in clause 4.2.6 is concerned, comma, however, comma, since the WBSEDCL has already been paying extra in amount of interest by giving credit of the same to the respondent number 5, comma, which transpires to be a bona fide mistake in view of the arguable case made out by the parties, comma, the WBSEDCL can be relieved of the liability to pay such additional amount of interest on the amount of security lying with them. Full stop. However, comma, there is no scope of the WBSEDCL withholding the security deposit of rupees 1,210, 831.04p, and the same has to be returned immediately to the petitioner. Full stop. Accordingly, WPA 4153 of 2023 is allowed, comma, thereby directing the WBSEDCL to refund the excess, refund the security deposit of rupees 1,210, 831.04p to the petitioner within May 31, 2023. Full stop. In the event such payment is not made within the date as stipulated above, comma, the WBSEDCL shall pay interest at the rate of 6% per annum for the entire period till such disbursal is made in favor of the petitioner, comma, on the quantum payable as on May 31, 2023. Full stop. No orders to cause urgency.
My lord, upon production of documents.
No
Or-
further.
Original documents has to be because the well, as per procedure, it is
My lord,
required.
may I-
Otherwise,
with you
My lord, one, one indulgence, no further submissions, only one small indulgence. I leave it to your lordship. With respect to the document that they had disclosed on page 26 of the affidavit in opposition, they state that there was an amount of cash which your lordship has taken as 1210831 point so and so. My lord, that amount has been given by WBSEDCL as the amount standing as on the date when they enter into the premises. There is an amount of interest calculated on the cash payment, which is prior to the respondent number 5 entering the premises. So that interest amount has already been quantified. If I could only—
When did you claim the refund first?
My lord,
when did you claim the refund first?
Around the same time, my lord, when they give this, even though I didn't have this document, my pleadings in the REIT application takes into account this amount. No, I'll not waste your lordship's time. I'll leave it to your lordship. But the claim is inclusive of
fodder for
interest.
the appeal court.
No,
no further.
I'll not. May I just make one? I'll just take 30 seconds, my lord. Lordship rejects my prayer. May I only say 30 seconds, just from the court's satisfaction, my lord.
You've already exhausted the 30 seconds.
Lordship, there was an amount, my lord, which is 1210831, along with an amount of interest, which is 65,384. They calculate the interest on my cash security deposit prior to the respondent number 5 ever coming into the scene. That amount they themselves, WBSEDCL, has quantified. If they didn't quantify it, I wouldn't press this prayer. They've quantified this amount of, it's on page 26. It's there. The respondent number 5 has disclosed this. And it's a part of my claim in the REIT application. I'm not asking for something
They went on giving credit of that interest amount to them.
No, they aren't, my lord. They are not. They are calculating the interest therefrom upon the amount of 1218 that they've deposited. With respect to this is an amount of interest already calculated and quantified prior to the respondent number 5 coming.
Kole, what do you say to that interest?
my lord, so far prior to that, my lord, that as per law, my lord, we are
That is 65,000.
65,000. It's quantified prior to the respondent number 5.
We've already get
And it
adjusted
also says
because
interest.
the
interest on
already
cash.
not- time to time interest will be refunded. That is the law. Regulations provide that.
65,000 you have admitted till that date.
No, that is quantified at that point of time. Subsequently, that litigation was come 2014 and all these things.
They'll be entitled to more.
I'm
No,
not
they are
claiming that.
entitled, as per my,
I'm not claiming anything
because
beyond this.
the entire
65,000 you have admitted where?
In page 26 of the affidavit in opposition, it's the document. Give- Page 26 looks, lordship looks at
Yes,
page
Mr.
26.
Kole to pay that also. He's right. His 30
Page
seconds have been
65?
fruitful. একবার দাও দাও
page 30.
Page 36 টা বার করে দাও। Their opposition.
The opposition filed by the respondent number 5, my lord.
Page 30.
The document has been shown
No,
by
that is not their admission. That's respondent of 5.
this document is by West Bengal
No,
State
no, no, no,
Electricity Supply Corporation. Electricity Distribution Company.
Page.
26.
দিয়ে দাও ওটা। হ্যাঁ হ্যাঁ ঠিক।
This document has been shown to your lordship several times by several parties.
Eight
So I'm
number.
taking one chance, my lord. It's lordship looks at the middle.
No, that is,
interest,
will kindly
interest
consider-
on cash.
Kindly see the date. Prior to that, my lord, initial sale.
31st of March 2015.
No,
They come into the
prior to
property
that,
after.
2014 sale proceed was commenced.
How is that
Subsequently, that
related
was
to the interest
rejected.
amount?
When did you apply? Where is that?
My application, lordship is referring to my original application.
No, application for refund.
Refund.
Lordship will just
So that is letter on 2016.
One second.
16 onwards.
My first representation is 24th of May 2016.
Yes. After this.
After this, that does. But I am
Interest has to be paid after the refund amount.
Yes.
After the refund claim.
I am not asking for the interest from that date to 26.
Nothing further, I'm sorry.
Very well. I'm deeply obliged.
We'll argue, but no.
Grateful.
Call on next guy.
I had very little job to do, my lord, after my senior.
No, not that, not that. You argued very well on the little. Yes.
23.
23.
Only thing, my lord, I am not in this matter. In the previous matter, my lord was looking into the compilation. The regulation 52, my lord, will get it in the miscellaneous provision of WBARs.
No, I've got that.
That is there.
Over and above, they handed over a copy, marked copy, therefore I took.
I thought that my lord was.
No, I got it. Got it. Thank you, Mr. Mukherjee.
My lord,
Yes, Mr. Bhattacharya. Nothing in your matter?
yes, my lord, here, my lord, the petitioner's mother, that is the private respondent,
who participated in an auction procedure, purchased the property, sales certificate issued on March 2022, and it was registered on December 9, 2022. Subsequently, I have my son.
Grievance. First, tell me the grievance, then we'll go backwards.
I have applied for electricity. They are asking for the area of 8 lakhs and odd. And it is in their opposition, they have admitted that this area caused due to the not the erstwhile owner, the licensee of erstwhile owner.
Same premises.
Premises.
You say there is no nexus.
There is no nexus because the one Srimanis, they took a loan from the Punjab National Bank. They are defaulted, surface proceeding initiated. I purchased the. They means the Srimani, the previous owner. Now, the Srimani entered into a leave.
You purchased from Srimani.
I am an auction purchaser in a surface proceeding. The Srimani is the borrower. Now, Srimani is entered into a license agreement.
I understand that licensee left that deal.
Yes. So, in any event, there is no nexus between the petitioner and the.
Yes, Mr. Mukherjee, what is the nexus?
But kindly straightway turn to my lord, page 19.
19 years.
Opposition.
No, my lord, sorry, my lord, it's my affidavit in opposition. But affidavit in opposition affirmed on, if you let's see, that has been affirmed on
by Sushobhan Bala.
16th March 2023. Now, my lord, kindly see my lord, first page 10. This is the leave and license agreement in between one Srimani and one Probit Chaudhary. What happened? Probit Chaudhary enjoyed the electricity. Subsequently, my lord, he left. Now, my lord, this particular Srimani took loan from the Punjab National Bank. Ultimately, my lord, loan could not be repaid. My lord, thereafter, what happened? Thereafter, my lord, property was auctioned. When we came to learn, my lord, this particular Probit Chaudhary not only enjoyed the electricity, but there is the allegation of theft of electrical energy. And there is a due.
You were the borrower. You had committed the default for which the surface sale took place. You are the owner. Now, yes, that Probit Chaudhary left some dues. So what?
Probit Chaudhary left some dues. Now, my lord, the Srimani is the owner of the property. Srimani
was the owner.
Srimani was the owner. Srimani executed a leave and license agreement with Probit Chaudhary. Probit Chaudhary, my lord, has committed some theft. Now, my lord, there is a dues. Now, my lord, he left. Now, this Srimani, my lord, could not repay the amount. Punjab National Bank, my lord, auction the property. Kindly see our letter. When we came to learn,
the debt was not of Srimani. The debt was left by Probit Chaudhary. Probit Chaudhary was consumer all along. He left the dues. He left.
Madam, I want to show to your lordship.
How is Probit Chaudhary? How is Srimani even connected to that debt?
I'm showing to your lordship. Madam, the original owner of the property is
Srimani.
Now, madam, this Probit Chaudhary, according to us, who has committed, but kindly see two things. First of all, madam, when we came to learn, we intimated the Punjab National Bank that look here, there are some dues from the premises. There are some dues. Your lordship may put a question to me that madam, that as the Srimani was not the consumer, how the Srimani is liable to pay. Now, madam, there is, I will show the nexus. Because madam,
between Srimani and Probit Chaudhary.
Yes.
And what is the nexus between him and either of them?
I am showing to your lordship. Because madam, had it been the case that we have not intimidated them, now madam, before that,
intimidation is nothing.
Kindly see the sale notice once, madam. Sale certificate, I will try, madam. I will try. Madam, kindly see, madam, once my affidavit in opposition in paragraph.
What is the sale certificate, Mr.
Sale certificate has been annexed by the writ petitioner. In his writ petition, I have stated. But if your lordship kindly permit me to read, my lord, for my opposition, paragraph 6. This, if your lordship kindly permit me. That, my lord, this deponent submits that the legal heirs of Sudipta Srimani and Supriya Srimani could not repay the loan for which Punjab National Bank initiated a proceeding under the SABYASACHI Act. This deponent submits that subsequently the property was auctioned and the sales certificate has been issued on 30th September 2022 in favor of the auction purchaser. That is the respondent number 6. Kindly see once the sales certificate that has been annexed in the writ petition. If your lordship kindly straightway come to the sale certificate, that will be at page. কত নম্বর পাতা আছে? না, sale certificate.
ওটা হচ্ছে এইটা।
But kindly see page 29.
Yes.
Now, my lord, if your lordship permit me that the line starts with property schedule, your lordship has got it, the paragraph property schedule. Before that, my lord, 3 lines. The sale of the scheduled property. The sale of the scheduled property, have your lordship got it. The sale of the scheduled property was made free from encumbrances known to the secured creditor as per e-auction sale notice, except municipal taxes, electricity bills, service charges, and other miscellaneous charges, etc. Now, my lord, what happened, my lord, kindly see the date. This is the dated 30th March 2022. Now, my lord, when we came to learn, my lord, kindly straightway come to my opposition, annexure R3. But
Page?
Page 19 of my affidavit of opposition.
Yes.
But this, what happened, my lord, initially the mother of the petitioner applied for new connection. She was informed that is the dues. Thereafter, my lord, bank wrote a letter to us. Kindly see the date 26/4/2022. This has been later dated by the bank.
How does the mother of the petitioner come in?
Because initially, mother of the petitioner applied for new electric connection.
Acha.
Because, my lord, the auction purchaser is the mother. Auction purchaser is the mother. Now, my lord, mother initially applied for new electric connection.
Who is he? He's just a resident there.
He is the son. Subsequently, a agreement has been issued in between mother and son. Son has applied for new connection. Now, my lord, kindly see, my lord, page 19. This is to inform you that the bank has sanctioned financial assistance to the tune of 2.15 crore as cash credit and rupees 14.57 lakhs as term loan, that is total amounting 2.29 crore on 27 June 2009 for running a business in the name and style. But this is irrelevant. Kindly straightway come to page 21.
Yes.
Sorry, my lord, page 20. Page 20.
20, yes.
Last but one paragraph. Thereafter, the said purchaser had contacted your office on 4th April 2020. Page 20.
Yes.
Thereafter, the said purchaser had contacted your office on 4th April 2022, when the said purchaser was shocked and surprised to see that there was no electricity and meter was not working. Thereafter, the said purchaser made inquiry regarding the same and found that an amount of rupees 8,84,568 is due and payable. Since the above mentioned properties were mortgaged with the bank and after the account was classified as NPA, the borrower mortgager had ceased to run the business, and after perusal of the aforementioned amount, claim towards the pending electricity bill is unjustified and need to be revised. It be mentioned that the said purchaser is ready and willing to settle the dues mentioned in the electric bill. Kindly mark that portion.
This is the bank's
I'm coming, my lord. I'm coming.
stand. I mean, how are they affected?
I'm coming, my lord. Because my lord, the sale certificate, registered sale certificate has been entered after that. After that.
Acha.
Kindly see the sale certificate, that will be page 18 in the writ petition.
Oh. But even then, suppose Mr. Mukherjee, they came to know of this. How could there be a nexus?
But if, had it
I mean,
been,
they were already they were designated as the purchaser.
only sale certificates were issued when on March 2022.
Maybe.
I'm coming. I'm trying to. But the thing is that it is not the case. It is not the pleadings that they have forcefully or they have compelled to agree that they are willing to clear the dues. And kindly see, when the bank is writing the letter, his right will come subject to correction.
They cannot be they cannot be bound by the bank's admission. One. Secondly, even the bank is saying they are being referred to as the purchaser.
Yes, must kindly see, On behalf of the purchaser, this bank is writing.
Why were they referred to as purchaser on that date?
My lord,
Why were they referred to as purchaser? The auction purchase had taken place.
auction purchase sale, my lord, registered only on 9 December.
That is the finality of the sale.
Finality.
But the process had started.
Process has started, my lord. After process, only my lord.
They had paid the consideration for it.
That is in between them. I don't know. Now, my lord,
Obviously, otherwise, how could the process start?
the process, my lord,
They
start.
must have paid at the inception. This is a bank sale.
That is there, my lord. Kindly see the bank statement. I will
What
show
is the nexus between them and Probir Choudhury? Come on, Mr. Mukherjee.
My lord,
I was going to say Mr. Choudhury. Then I realized.
but thereafter, my lord, kindly see the what happened, my lord. Thereafter, our reply kindly consider.
Thereafter, whatever happened, happened.
But they have agreed to settle the dispute, my lord. Kindly
Who has agreed?
the bank.
I'll settle it. Bank? Settle it with the bank?
Bank on whose behalf? Kindly see the letter.
How can they have authority to do that?
My
On
lord,
their behalf?
but that is
Bank was their power of attorney holder.
but now, my lord, kindly see the third line, my lord, their application. If I can satisfy you.
Third line of what?
Third line of, my lord, here his application for new connection.
Where is that page?
Page, it starts from page 24.
Yes.
Now, my lord, they have to give a certificate, my lord, regarding the undertaking of the applicant. In the undertaking, they said that there is no other meter standing there, but there is an existing meter which is not operating. If your lordship permit me, my lord, I can.
Where is that?
Yes, my lord, that will be at page 25. If your lordship see 7, we hereby further declare that we have service connection in our name, such and such, and no outstanding dues exist. There is no restraining order from any court. No, there is. Yes, madam. We hereby further declare that there is no other service connection live or disconnected in the said premises. But ground number 6. But this is wrong because there is already a connection not live, but there is a disconnected meter. This state.
We further declare that no restriction in relation.
No, we further declare there is no other service connection. Point number 4, my lord, if your lordship consider.
4 or 5 or 6?
4.
4 years.
We hereby further declare that there is no other service connection within bracket live or disconnected the same premises having outstanding dues for which the new service connection is being applied for. This is wrong.
Even if this is wrong. What is the nexus between him and Probir Choudhury?
No, I am not. For this matter, I am not on nexus. But nexus.
You have to be only on nexus if you want to claim this outstanding dues. That is the only handle you have, Mr. Mukherjee.
But accepting this, I can't.
This is a different ground altogether.
This is my second ground. First ground, my lord, that
hang them for this.
I will. My first.
Go before the criminal court, hang them.
That is, my lord.
Till death, if possible. But you cannot do this to them. Claim this outstanding amount.
This is the only way. Otherwise, the nexus, I only for this thing that the Punjab National Bank has stated. No other.
So his present grievances, he has asked for electricity or asking for that outstanding?
Outstanding, and we have not inspected. And after that, we will, if your lordship order.
You are CSC or
distribution.
The petitioner's grievances.
Can you record this submission regarding this bank and others, my lord?
The grievance of the petitioner is that the petitioner, being an auction purchaser of the premises in question, applied for a new electricity connection. However, the WBSEDCL declined to give such connection unless the petitioner deposits the alleged outstanding dues with regard to the same premises in respect of a previous defaulting meter. Next para, it is argued that there is no disclosure of any such liability in the sales certificate or any other document executed between the bank and the petitioner, and there is no nexus between the petitioner and the erstwhile defaulter. Hence, the WBSEDCL, in law, have no authority to insist upon prior payment of such alleged outstanding dues before giving a new connection to the petitioner. Full stop. Next para. Learned counsel appearing for the WBACTCL refutes such contentions. Full stop. It is argued that in the application made by the petitioner for new electricity connection, comma, one of the clauses within bracket clause Roman 4, small Roman 4, bracket closed, the petitioner declared that there was no other service connection within bracket live stroke disconnected bracket closed at the same premises having outstanding dues for which the new service connection is being applied for. Full stop. Next para. It is, comma, however, comma, sorry, evident that by a previous letter dated April 26, 2022, comma, also annexed to the affidavit in opposition of the respondent number 5, comma, that the petitioner was already aware of the outstanding amount of rupees 8, 568 oblique dash being due and payable in lieu of electricity charges. Full stop. By suppressing such knowledge, comma, it is argued that the petitioner sought to obtain the connection. Full stop. Moreover, comma, since the sale was on as is, where is, and whatever there is basis, comma, the petitioner was liable to pay all outstanding dues, comma, including the outstanding electricity charges left with regard to the premises. Full stop. Next para. It is seen from the documents on record that one Srimani, that the Srimani apostrophe দিয়ে করে দাও, Srimanis were the erstwhile owners of the property and the borrowers, comma, against whom the bank initiated the SARFAESI proceedings. Full stop. Under the said Srimanis, comma, one Probir Chaudhary was a licensee, comma, who had allegedly left outstanding dues for user of electricity. Full stop. Next para.
Unauthorized use.
Full stop. Although it is contended by the WBACTCL that the petitioner is liable to clear such outstanding dues, comma, there is nothing on record to establish any nexus between the petitioner and the said Probir Chaudhary, comma, that is the defaulting consumer, comma, at any point of time whatsoever. Full stop. Even if it is assumed for argument apostrophe's sake, comma, that the petitioner, comma, after deposit of the consideration amount in the auction sale and commencement of the process of sale, but before the issuance of the sales certificate, comma, learnt of such outstanding dues left by a previous consumer, comma, the same, comma, being post facto knowledge, comma, cannot per se indicate any nexus between the petitioner and the erstwhile defaulting consumer. Full stop. That apart, comma, the within double inverted admission, double inverted clause, in the communication dated April 26, 2022, made by the bank to the WBACTCL, cannot, comma, in any manner, comma, bind the petitioner even as regards the knowledge of the petitioner about the outstanding dues. Full stop. Since the petitioner never made any communication whatsoever to the effect that the petitioner had prior knowledge of the outstanding dues, comma, before the commencement of the auction sale process, comma, such liability cannot be fixed on the petitioner to clear the outstanding amounts alleged to be due with regard to a previous defaulting consumer, comma, even as per the regulations framed by the WBERC under the Electricity Act 2003, comma, which is binding on the WBACTCL. Full stop. Next para. Hence, comma, the demand made by the WBSCDCL from the petitioner of clearance of the alleged outstanding dues left by a third party cannot be a ground for refusal of electricity to the petitioner. Full stop next para, hence, WPA 4171 of 2023 is allowed, thereby directing the WBACDCL to give a new electricity connection to the petitioner as expeditiously as possible, positively within a fortnight from the compliance of all due formalities by the petitioner in that regard, without, however, insisting upon or claiming payment of the alleged outstanding dues left in respect of a previous defaulting meter in the same premises from the petitioner. Full stop. No rest to cause certain certificate. Sorry, Mr. Mukherjee, but no, next, sir. What to take it? Yes.
24.
You agree to an order, I mean, I can. Otherwise, in 1 minute.
New connection, my lord, they are disputing.
Oh, you are there?
Yes.
No, we are in the
You see,
same,
my land is for
we are in the same,
Same boat?
same team. Mr.
Same.
Pachanani.
No, he is there. He is the differentiating factor.
No.
Not you.
If I will respond,
Who is the petitioner?
I am for the future.
I'm for the
You are wanting new electricity connection.
I'm for the response of 5 minutes. I led by Mr. Sarko Sen Malet. I'm paying for not today Malet. Last time.
Day one, Yes, I think.
Don't go by his
Malet
instructions.
supplementary file.
Come back tomorrow. Come back tomorrow.
The order will.
A supplementary file.
No order. So many people at that order.
Malet supplementary affidavit file Malet. Last time.
Due to paucity of time, the matter cannot be taken up today for hearing. Full stop. Hence, let the matter stand adjourned till tomorrow.
Malet supplementary affidavit filed by the respondent file kept it.
No. Due to paucity of time, I cannot take anything. Be present tomorrow when I take up the matter. If you file the supplementary affidavit, you have to do the matter, Mr. Mundal. You come prepared in the matter.
নাম দেবো
হবে না বাথরুম
এই নাম লিখে দাও নাম লিখতে হবে এটা সিএসসি
তাহলে কালকে লিখে দেবো
কোনটা কোনটা
কোনটা respondent file
তো লিখতে হবে দেখো না এবারে
কি দিচ্ছে এগুলো কিন্তু মা কাকে দিন দেবে